Maybe father to mention Miller. An application for interim. If possible,
Division में मैट
interim.
डिवीजन में मैट
Yes.
मोर बेल असाइनमेंट अछि
2010.
अपील रे ईयर तक
10.
ठीक है हम
Yes.
साइन ठीक
Supplemental list item number 1.
Made, please, Your Lordships.
yes yes Mr. Das
Yes.
start your
My lord, here it's an appeal against the judgment of conviction and order of sentence under 302 and for life, respectively. Your Lordship said, to a great extent, heard us on the earlier date. My lord, my sincere apologies that I was a bit not prepared that day. I'll
It's
try
all right.
ably to
Start,
assist
there
Your
is no
Lordship today.
problem.
My lord,
You present the case on your own way.
Lordship. Here, my lord, the question before Your Lordships is not that whether the act by the accused is that of a culpable homicide or not. But rather the question is that whether the culpable homicide amounts to murder or doesn't amount to murder. My lord, in that, my lord, the sole submission that I would like to urge is this, that the prosecution case that the accused came dealt with a blow, meaning it is said that he assaulted the deceased, is found to be reliable or not. My lord, so far as PW1 is concerned, that if Your Lordships recall, in the cross has been discredited by himself.
Please.
Lordship. Page 59, my lord. The foundation of the prosecution case to begin with, my lord, rests with these three evidences of PW1 happens to be the father, the complainant of the deceased, and the accused. The accused and the deceased are brothers. PW2, the brother of the wife of the deceased, and PW4, the child witness, this minor son of the deceased. My lord, if sees page 60, in the cross, he disowns his own version. So there my proposition is this, Your Lordships, that other circumstances, so far as his statements before the magistrate, his version before the police, cannot now be resorted to.
No. How many witnesses the prosecution has projected as eyewitnesses to the?
Lordship, here the prosecution projects three witnesses as eyewitnesses. There are PW1, PW2, and PW4. The ocular evidences are of
these persons?
PW1, my lord, is the father of the deceased and the accused.
Obviously, father.
Lordship.
Yes. Then 2.
PW2 is the wife of the deceased.
Okay.
PW4 is the minor son of the deceased.
Yes.
My submission is to that the eyewitness in this case, if these depositions are carefully read together holistically, my lord, what comes to a relevant inference is that the eyewitness only is PW4.
PW1 is the informant in the case.
Is the informant the father? Yes.
Okay. So why will disbelieve the father? What is your submission to that? He has stated in the chief examination if come to the
Fif-
evidence of PW1.
PW1, my lord, page
Yes.
59.
Yes. Please place the evidence and make your submission that why.
Lordship. My lord, the occurrence, second line, my lord. The occurrence took place on 9/12/13 at about 7 p.m. At the time of incident, I was in my house. On hearing a sound, I came outside of my house and had seen the accused was assaulting the deceased by means of a stick to the head of the deceased, as a result of which bloods were oozing from his head. Deceased was immediately taken to hospital, so on and so forth, my lord. If your lordship takes the next page, which is the cross page 60 of the paper book, there he says, my lord, I used to live in village Arpata. The distance between village Arpata and village Dhanuria is about 3 kilometers. My house means the village Arpata. The incident and occurrence is at village Dhanuria, my lord. Then the next line, I was not present in village Dhanuria on the date of occurrence. I had not seen the occurrence. On being instructed by police, I had lodged the FIR. The police dictated the FIR to me.
What is the name of the village where the occurrence took place?
Dhanuria, my lord. My lord, here my submission is that the evidence of PW1 now cannot be relied upon by the prosecution clearly because of the version coming forth in the cross, my lord, as well as his versions in form of statements before the police and as a complainant, the version in the FIR also cannot be looked to and are not valid materials of reliance.
So your submission is that since whatever he has stated in the chief examination to have seen the occurrence
Lordship,
has been given a go by in the cross examination,
Lordship,
wherein he has stated that he had not seen the occurrence and police dictated the FIR, so that is why he cannot be said to be a truthful witness. That is
Lordship,
your
Lordship.
But even if we, let us say, your submission is accepted and we disbelieve PW1, but what about these other two eyewitnesses?
Lordship,
Two
so
and
far as
four,
so far as they are concerned, my lord, your lordship sees page 61.
PW2.
Lordship, I'm so sorry, my lord. So far as that PW1 is concerned, one more submission to that effect is PW1 in his chief nowhere is saying about presence of PW2 and PW4 either at the beginning of the incident or during the incident.
No, when he himself was not present at
Lordship,
the scene of occurrence,
no, my lord,
he is not supposed to say who were present.
Lordship, but the prosecution
His
case
evidence is to be completely
discarded as a
So
whole.
you
My lord,
cannot
I'm
take
grateful.
one piece
In
of evidence
bits
from
and
him
pieces.
and to discard the evidence of the other witnesses,
Lordship.
because he himself has given a go by to whatever he has stated in the chief
Own
examination.
version, Lordship.
So now, on the basis of PW2's evidence or other evidence, you can, or medical evidence, you may say that PW2's version is not acceptable.
Absolutely, my lord, I'm grateful.
But when if one witness has stated something and we accept him as an untruthful witness, if your submission is at all accepted,
Lordship,
relying on his statement, the other witnesses cannot be. It is to be appreciated on its own, whether that is
grateful.
yes.
Now, so far as PW2 and PW4, my lord, are concerned, if they are read, I would like to draw your lordship's attention to page 61, my lord. The deposition of PW2. Lordship has it.
Yes.
Second line, my lord. Third line, my lord. I was in the house at the time of incident. At the time of incident, the deceased, after returning from village Sandi, was making a bamboo tatti near the veranda of the house along with his son. Here, my lord, may kindly note, he was there along with his son. The deceased was present along with his son only.
His son means PW4.
4.
Okay.
Suddenly, my son called me by saying, Bolo mari pakaila. On hearing this, I immediately came to the spot and had seen that the accused was assaulting the deceased to the head of the deceased in a thenga, and thereafter the accused fled away from the spot, my lord. This, my lord, is to be read, to pause for a moment and take page PW4, my lordships. Version at page 65. Just may take page 65 for a moment, my lord. It starts at page 65. Page 66, I would like to place, my lord. The line starts with at the time of incident. My lords, if
Page
lords have it.
66.
Lordship.
At the time, okay.
At the time of incident.
Five lines from the top.
Lordship, I'm grateful.
Yes, yes.
At the time of incident, my father was making a bamboo tati and I was there with my father. Suddenly, the accused, my uncle, being armed with an acacia stick, assaulted to the backhead of my father. I raised hula by calling my mother. He raised hula by calling his mother. He never left the spot, your lordships. And my mother immediately came to the spot. At the time when my mother came to the spot, the accused fled away. At the time when the mother came, the accused immediately fled away. So, my lord, there is no reason to believe that PW2 came to the spot and could see the accused assaulting.
No, we put a question to you,
Lordship.
that you see, the lady was inside. On the veranda itself, the deceased and PW, this 4, they was present and the deceased was preparing their bamboo tati, right? So suppose, and as it appears, there was no previous quarrel like that. So came, assaulted. If that would have been the state of affair,
Lordship.
and it would have been a case of one blow,
Lordship.
then you could have very well said that by the time the lady came from inside the house, so it was not expected that after assaulting would be there present and you would notice the further assault. But it is a case where number of blows have been given as it appears from the
medical
medical evidence.
only. Solely that is the place.
So the possibility of the lady coming to the spot after hearing the cry of her son, reaching, coming outside and seeing the occurrence, a part of the occurrence. We do not say that she will be able to see all the entire assault,
Lordship.
because the voice which has been given by the son is Bolo Mari Pakaila, means it presupposes that the assault has already commenced.
Yes.
Right?
Yes.
Because prior to that, there is no evidence that there was any quarrel. So
Lordship,
came,
that has not
assaulted.
Yes.
So Bolo Mari Pakela, it would come thereafter only. So thereafter, suppose one blow would have been there. So this is the appellant dealt and left. So the lady who was inside coming out, she could not have been in a position to mark further assault. But here is a case where number of blows have been given as it appears. So in such a situation, how can you say that this lady would not have been in a position to mark any assault at all?
Lordship, because if both the versions are read together, that is what is the inference that falls. If your lordship sees, the minor says, Boulo Maripokaila, on hearing this, immediate the accused was assaulting the deceased and I immediately came. This is the version of PW2, your lordships, the wife. On hearing this, I immediately came to the spot and had seen the accused. She is saying that on hearing the alarm, I reached the spot and I saw.
No,
To the absolute.
Who has stated that PW4 went inside, called his mother to the spot?
No one, my lord.
No one
No one
stated.
is stating.
So it is only PW4 was all along present
yes.
by the side of his
Yes.
father, and he stated to have seen the assault. And the moment the assault started, he made the cry, and that cry is Boulo Mari Pokaila.
Pokaila. Lordship.
And the bow was inside, means PW2 was inside. She is coming out.
Outside, and the accused fled on seeing her. That is the version. Your Lordship takes page 66, my lord.
At the time,
Suddenly, the line
At
starts.
the time of the coming to the spot means, may suppose there would have been a chance to mark something
Yes.
from a little distance. So
That
the
cannot
moment
be.
one reaches at the spot, the might be at that point of time, the accused is leaving. But you cannot say that it would not be possible.
Lordship,
I
I
am
bow
here.
down to that, my lord.
If that would be the spot, I can see the occurrence from
Yes,
here
yes,
also.
yes, yes.
So the moment I reach there, by the time the occurrence is over and the assault is over, you might be leaving. So it can be reconciled, but
Yes.
mean to say that it is not such a statement which should at all disbelieve the entire evidence of. And one thing you must keep in mind, there was no third person available,
No.
right?
Right.
And these two witnesses are not only related to the deceased, they are also related to the appellant.
Yes.
And in such a situation, they would not have spared the real culprit and implicate somebody falsely. The occurrence is taking place on the veranda of their house.
Yes.
Son is there on the veranda, mother is doing something inside the house. So son saw the assault, started shouting, mother came, and number of blows have been given. That was the vital factor. It would have been one blow, matter is different. But
Lordship,
since
my
number
dear
of blows is given, and Boulo Mari Pokaila, you cannot also state that Taku Sunila Pare, ଛୁଆର ଡାକ ଶୁଣିଲା ପରେ ମା ତାର ସେ ରହିଥିବ ଆଉ କିଛି ସମୟ ପରେ ଆସିବ, because ଛୁଆଟା ଯେତେବେଳେ ଡାକୁଛି ବୋଉଲୋ ମାରି ପକେଇଲା, something has happened, so immediately the response should come and she would come outside. It is expected. So ସେଇ situation ରେ ମା ଆସିକିନି ଯଦି blows ଦେଖି ପାରୁଛି, cannot be said that she would not be in a position to mark any assault at all. May not be the entire assault, but at least some assault, because how many blows have been given?
That number of blows, nowhere it is stated, my lord.
No, we are not saying
Lordship.
so, but you see, these are all separate blows. It cannot be said that with one blow all these injuries are possible.
Lordship,
because it is on the different parts of the head.
Yes, yes.
The scapula is there,
Lordship.
and so maybe these abrasions may be possible when after receiving that blow he fell down on the ground or something like that. But the different blows have been given, right, left. It cannot be possible one blow. So more than one blows have been given.
No, my lord, only to the skull. My lord, only on the head.
Right.
The injuries are only on the head. To that, my submission would be, my lord, the head is such a part which is constituted with soft bone. So one blow would or may cause other damages and cracks at other parts.
You see, come to the first one.
Lordship.
The first one is on the left ear, here.
Lordship.
It's a fracture injury. The other
upper pole of
second
left ear.
blow is on the head, vertex.
Vertex of head.
The third blow is on the scapula, right side scapula. Fourth blow is, so these are different parts. You cannot say he will give one blow, all these these injuries would be caused. If it and if that would have been so, then it was the duty of the defense counsel that with one blow all these injuries are possible. If you will not give it, we will just see in general line that whether it is possible or not.
Lordship.
So what you say that with one blow there may be some kind of fracture from that side, this side. So I should have confronted to the doctor, got a clarification
Yes.
from that. So let
Yes.
us say one blow is given, whether all these injuries are possible or not.
Are possible, and even whether all these injuries would be possible by means of an acacia stick,
No,
blow caused by acacia stick.
that
That, my lord, has not been marked
no no.
in MO, nor been
He,
produced
he,
in trial.
he has stated, I think it has stated that it's a blunt object. It has been caused. I think there is some kind of statement.
If your lordship sees the opinion by
Uh,
hard and blunt trauma,
Hmm.
that your lordship probably is referring to.
Mhm.
Page 87, my lords.
Craniocerebral injury, so on so.
There was a landed dispute also. That also comes, but your lordship, my endeavor to that effect fails when the defense has not been able to
No, no,
throw sufficient
when a
light.
case is based on direct evidence,
Ocular evidence,
so motive becomes insignificant.
lordship.
In a case of circumstantial evidence, the motives assumes
Relevance,
importance.
yes.
But in a case of direct evidence, when wife and son are, if we discard the evidence of PW1, the father, because of his contradictory statement in chief vis-a-vis in the cross examination, two witnesses says one was present very close to the father and supposed to have seen the occurrence, called the other one, and the other witness corroborates the version of and you see the this statement, this just shouting by PW4, it amounts to resisting because he shouted after seeing the his
Yes.
conduct is that it is admissible under section 6 of the Evidence Act, and that attracted the attention of the mother who was inside.
Yes.
She immediately came, saw the occurrence. So these two statements, unless you succeed in dislodging the evidence of these two vital witnesses, it is very difficult to accept that they are to be discarded in toto and uh,
Well, my submissions are
hmm,
subject to your lordship's considerations that PW2 cannot be treated to be an eyewitness.
hmm,
That is, my lord, one, because the versions of PW2 and PW4, if read together, my lord,
hmm.
that inconsistency comes out.
No,
But your lordship's
because of that one line which you are relying
lordship,
from
lordship.
the evidence of PW4,
But
that my mother came and then
but in
I raised
response to
Halwa,
that,
my
your
mother
lordship's
immediately
observations, my lord,
came.
I
At
bow
that
down.
time, my mother, at the time, when my mother came to the spot, the accused fled away. So that particular line you are harping, but again we are telling that what is that? Whether it would not have been possible on the part of the
It
mother
would
to
have been. It
mark
would have
the
been.
assault from a little distance.
It would have been, my lord, because the defense has brought nothing to state that how this spot is placed, how the occurrence is placed. It is said to be in the
ଆପଣ
veranda, so probably in the front
ଏଭିଡେନ୍ସ
veranda or the
ଯଦି
central
ଆଣିଥାନ୍ତେ
veranda.
ଯେ ପର୍ଯ୍ୟନ୍ତ ଘର ଭିତରୁ ଗୋଟେ ଲୋକ ବାରଣ୍ଡାକୁ ନ ଆସିବ
Again,
ସେ ପର୍ଯ୍ୟନ୍ତ ଘଟଣା ଜାଗା ତାକୁ
dekha
ଦେଖାଯିବ
jauga.
ନାହିଁ,
Absolutely, my lord.
ରାଇଟ୍?
Absolutely.
ଏ ଏଭିଡେନ୍ସ ନ ଆଣିଲା ପର୍ଯ୍ୟନ୍ତ ଯଦି ସେ ୱିଟନେସ୍ କହୁଛି ମୁଁ ଦେଖିଛି
Lord.
ଏବଂ ପୁଅ କହୁଛି ଘଟଣା ଜାଗାରେ ଯେତେବେଳେ ପହଞ୍ଚିଲା ସିଏ ପଳେଇଲା, ତେଣୁ ଟିକେ ଦୂରରୁ ହୁଏତ ଦେଖିପାରୁଥିବ ଏବଂ ସେଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ବା ସେଇ ସିଚୁଏସନରେ ସେ ଯେତେବେଳେ ଆଗକୁ ଯାଇଥିବ ତା ସ୍ୱାମୀ ପାଖକୁ ଏବଂ ସେତିକି ବେଳେ ପୁଅ ମଧ୍ୟ ଦେଖିଥିବ ଯେ ମା ଆସିଲା ଏବଂ ସେତିକି ବେଳେ ଆକ୍ୟୁଜକୁ ପଳେଇଲା, ତେଣୁ ଏ ଦି ଜଣଙ୍କର ଷ୍ଟେଟମେଣ୍ଟଟା ରିକନସାଇଲ ହେଇପାରୁଛି।
Paruch. Yes, 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 your lord. To that I bow down to, my lord. I have no response to that, my lord.
No,
Really.
it is just uh, a something is different in a case while you are arguing a criminal either in the trial court or you are preparing the case, cross-examining, or in the you must take yourself to that you
Yes.
visualize that as if you are there. what would have been in your reaction, whether it is so. Accordingly, if you keep yourself there, then you can prepare the questions like that while cross-examining, and you can argue the matter also in a
Yes.
better way. Not that this routine manner you can, because routine presentation is different. But once you go to the depth of the matter, you can place the matter in a better way,
Lordship.
because your appreciation would be good. So that is why it is stated that go deep to the matter, think, visualize the situation. And so here, two things mainly arise are against you. One is that the two witnesses who are deposing against you are not only your relations, but also related to the deceased,
Lordship.
and they have no axe to grind, and there is nothing that they would tell falsehood, and why they would spare the real culprit and implicate something, particularly when there is no evidence that anybody else was present in the vicinity to
Lordship.
commit the crime.
To that, my lord, my response is this, my lord, that PW2 and PW4 are definitely interested witnesses, my lord, because there was an existing civil dispute. So that motive though was there, but what I'm trying to
Related witnesses are not necessarily interested witnesses.
Lordship,
Related with interested witnesses means he would get some advantage out of it. That is called advantage. They are related means they are somehow or other they are related to the person who
yes,
is dead. But question is that by telling what benefit they will get. So
in
interested and related,
that
and number of citations
in
are there,
yes,
that it cannot be, rather they would be the last person, as we said, that they would not spare the real
real
culprit.
culprit, my lord, that is there, my lord. There is no third person coming in, falling in within the
No.
implication sphere. But what I'm trying to bring is, because of a prior civil dispute,
Hmm.
those two witnesses, vital witnesses, would be inimical witnesses, meaning they would be trying to implicate the accused, making all efforts to implicate the accused, my lord. That is my submission. Though, my lord, merely being inimical witnesses, the witness evidence cannot be discarded in totality unless and until there are adverse circumstances and evidences laid, my lord. That is a settled position, my lord. So that, my lord, if your lordships permit, I may be allowed to rely on a
That
decision.
about that civil litigation.
Lordship,
What is the material?
62, my lord. 62, the paper book, my lord. That is the cross of the, before the cross, paragraph 2 in the chief. The wife says,
PW2.
PW2.
Here.
My lord, if sees the last but one line, I suspected that the accused might have killed the deceased due to previous dispute relating to landed property.
That was his reason that there was some kind of dispute.
So definitely, my lord, there was
Page 66.
66.
Basically,
Lordship.
examination, para 1, examination 3, the last line.
So this, Mr. Das,
Lordship.
Last line, to my knowledge.
this is a double-edged weapon.
Yes, that is the
This
principle.
may be that it would be a ground for false implication,
Yes,
and on the other hand, it would be a ground to assault somebody. So it is like a double-edged weapon. So merely because somebody has disputed does not mean that whatever she has stated, it is it is false, and his evidence is to be discarded. Yes, of course, the court has to be check thoroughly the evidence, because there is likelihood of in such a situation to falsely implicate someone. The court
yes.
should put itself on guard to be more careful, minutely assess the evidence. But merely because there is some kind of because every most of the murders takes place on account of some kind of dispute.
Dispute.
Otherwise, why a normal person would kill another unless he's a terrorist like that?
Yes.
So mainly in village area, you will find that this is the reason:
Reasons.
landed
Yes.
properties or something, some dispute arose, some That is the so if we uh, give a proposition that there was litigation between them, civil litigation, so their evidence cannot be accepted on the sole ground, then it would just not be acceptable to anybody, and it will create a very bad precedent.
Yes.
So
Abro-
every case has to be appreciated on the its own
Own
facts
pattern.
and circumstances.
Independent.
We have to see that two witnesses are coming forward to say what has happened and surrounding circumstances, and most particularly the medical evidence corroborate what why the that weapon of offense was that was seized or not seized.
That weapon has not been marked, Your Lordships, in MO.
No, two lathis, as it appears from the providing report.
Broken
Two,
stick.
right, those two lathis. One is uh, broken lathi and 13.5 inch, and the other one is also the length is given, that is marked as exhibit C and D. Those were sent for a C examination,
Lordship.
and of course, in both the lathis, no blood was found, but no attempt has been taken by the investigating agency in sending the this lathi to the doctor.
No, my lord, if Your Lordship sees page 75,
Hmm.
second paragraph,
Hmm.
first paragraph, my lord. I was working as medical officer in charge. On that day, the police had produced a weapon for offense in PSK such and such, and later on turned to offense 302 for my examination opinion. Weapon of offense is non-sal stick. I have given the detailed description of weapon of offense in my report.
Hmm. What is his report, that it is possible or not possible? I had given the detailed description of the weapon. He has opined, he must have given the report after examining.
Report is exhibit 4, my lord.
Report is exhibit 4. What it says, that whether it is possible or not, those injuries, because he is not the doctor who conducted postmortem examination, but he is a doctor who was attached to CHC.
Yes.
The deceased died after 3 to 4 days, I think.
Yes.
4 days, right?
After being treated and
And
transferred
but,
to SCV
but
Medical.
he was also treated at Badasai CHC, as it
CHC.
appears.
Yes.
And
THH Baripada.
right, and this report exhibit 430 ke dekhiye le, exhibit
102 is the forwarding report, Miller, where serial number 3 is one lathi. That is exhibit C.
Yes.
exhibit 4 টা এইটি ଅଛି ତା ଦେହରେ ନାହିଁ ଇଏରେ এটা କହୁଛି identification of the weapons, non-sal stick, size ହଉଛି ଏଇଆ, ଏଇଟା ଦେଇଛି ନା କୋଉଟା କେତେ ସେଟା ଯୋଉଟା କି indicate କରିଛି। ହଁ। ଆଉ then injury caused on such and such ଏଇଆ injury ଅଛି, fracture injury. After it opinion. After examining the weapon, it was handed over to the accompanying ASI for production in the court of law.
It has not been
was
produced.
admitted in Bodasai CSC on so and so at 8:30 p.m. following head injury, and so weapon was produced. Break for a little. See what I got 9 there is. The opinion has been given that it is possible by this way.
Lordship.
That is Exhibit 4.
4. But that has not been marked as MO, my lord,
Which
nor
one?
produced in trial. The weapon, the
No,
stick.
it should have been produced, but as it appears that it was sent to for chemical examination.
Lordship.
Report has come, but it was the duty of the in the prosecuting agency to also produce that in the courts for purpose of identification. It could have been, it should have been also shown to the not only to the doctor but also to the 2 eyewitnesses,
Yes.
because they would have identified, which has not been done.
No endeavor from the defense side
That,
also.
that is one aspect,
Lordship.
but let us say that in one case the weapon is totally, the accused fled away with weapon. The weapon was and threw it in the river. Weapon was not recovered
At all.
Let us take an example. But the witnesses have stated and their evidence is believable. So merely because the weapon of offense was not recovered, can that be a ground to discard the entire prosecution case?
No.
Oh, and is the statement in the prosecution on the my grandfather's transfer had been this spot. And transfer had taken research to the grandfather admittedly that matter. Prosecution. My father was my grandfather had seen the incident. Other persons also were reached at the spot after hearing my bullet and had not seen the accused. He assured the grandfather, none of these persons are right there. Hearing the bullet. Then my mother, myself, and my grandfather had seen the assault by the grandfather. Myself have been examined by the grandfather is PW. He has admitted in a person that was not there. So anybody let us discard the evidence. Grandfather, this is not even it was an appeal. Grandfather the total package. But about this two number and number is supposed to proper mother and feed away. It's math, it's a sports math, right? Understood. So thus please turn to page 107, that spot map which was exhibited. Where is the incident occurred?
Lordship.
A, my lord.
Front courtyard.
Front court.
Just in front of the bedroom.
Koda.
Just in front of the bedroom, that is a spot like a occurrence spot.
Spot house of the deceased.
ता भितरे my lord.
লেখা
A
ହେଇଛି
भितरे
spot.
occurrence spot.
occurrence spot. तापर bedroom रो कबाटा खोला अछि. कबाटा दिया जियो. दीटा गारा दिया जियो door of the
But there is no evidence that my mother, she was inside the bedroom. So immediately after hearing the hula, she came out from the bedroom. That is not the
bedroom ने घर भीतर थिला.
ଘର ଭିତରୁ ଆସିଲା.
घर that is a room.
No one is saying anything.
Bedroom की नुहे that is घर.
Whether that occurrence spot was a blind spot.
bedroom हिसाବରେ ହୁଏତ use କରୁଥିବେ ସେଇପାଇଁ
ସେଇଟା ଗୋଟେ room ହିଁ ଦେଖୁଛନ୍ତି. That is bedroom, that is ସବୁ ମାନେ entire year ସେଇଟା ହିଁ ରହୁଛି.
ଏଇଟା ହଉଛି ଗୋଟେ ବାଉଣ୍ଡ୍ରି ୱାଲ୍ ଯାଇଛି, ତାର ଯୋଉ ଲେଖିଛି ନା ପକ୍କା ବାଉଣ୍ଡ୍ରି ବୋଲି ଗୋଟେ ହାଇଫେନ୍ ଦେଇଛି.
କାରଣ B ଟା ହଉଛି accused ର ଘର.
କୋଉଟା?
B ଟା.
ହଁ ଭାଇ ତ ଆଉ କଣ ଏବେ
ଆଜ୍ଞା.
ଏଟା ହଉଛି ଡିସିଜ୍ ର ଘର, B ଟା ହଉଛି
ମଝିରେ ବାଉଣ୍ଡ୍ରି ୱାଲ୍ ଅଛି.
ବାଉଣ୍ଡ୍ରି ଯାଇଛି.
ଆଜ୍ଞା.
ଆଉ ଏଇ ଯୋଉ ଦିଟା ବେଡରୁମ୍ ଦେଖେଇଛି ସେଇଟା ହଉଛି ମାନେ ଆକ୍ୟୁଜ୍ଡ
ବେଡରୁମ୍,
ରାଇଟ୍?
ଆଜ୍ଞା.
ତାଙ୍କର ହଉଛି ଗୋଟେ ବେଡରୁମ୍ ଯାହାର ପଛରେ ପୋଖରୀଟିଏ ଅଛି.
ଆଜ୍ଞା.
ଆଉ ସାମ୍ନାରେ ଘଟଣାଟା ହେଇଛି.
ଆଜ୍ଞା. ଏଇ ଯୋଉ ବେଡରୁମ୍ ପାଖରେ ଦି ସାଇଡରେ ଦେଖୁଛି ଏଟା ଖାଲି ଜାଗା ଥିବ, କାରଣ ଗୋଟେ ଡୋର ଦେଖୁଛି ନା କିଛି କମ୍ପାକ୍ଟ ଭିତରେ ତା ଭିତରେ ଥିବ.
ହଁ, ତେଣୁ ମନେକର ଇଏ ଏଇ ଯୋଉ ବାହାରିକିନା ଆଇଲା ବେଳକୁ
ଆଜ୍ଞା
ଏଠୁ ସ୍ପଟ ଟା ଯେହେତୁ ଦେଖା ଯାଉଛି ସେ ଦେଖିଥିବ
ଦେଖିଯିବ
କିନ୍ତୁ
ସ୍ପଟ କୁ ଗଲା ବେଳକୁ ସେ ପଳେଇଲା
ବାହାରକୁ ଆସିଲା ବେଳକୁ ଇଏ ପଳେଇ
ପଳେଇ
ଯାଉଛି
ଯାଉଛି ଆଉ
ତେଣୁ ପୁଅ ବି ଦେଖିନଥିବ ଯେ ମା କୋଉଠି ରହିକି
ମା କୋଉଠି ଅଛି
ଦେଖିଲା
କୋଉଠି
ବା ମା
ଦେଖିଲା
କୋଉଠି। ତେଣୁ ସେ ଏଗୁଡାକ ସବୁ କଣ କି ଏପର୍ଯ୍ୟନ୍ତ
Defense
ଜେରାରେ ନ ପଚରା
defense
ହେଇଛି
ରେ
ଏଗୁଡାକ
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ନ ଆଣିଛନ୍ତି
ଇମାଜିନ କରିପାରିବୁନି ତାପରେ
ଏଗୁଡାକରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଇଜ ଦ ଭାଇଟାଲ
ହଁ
ପର୍ସନ ଟୁ
ଆଉ
ବ୍ରିଙ୍ଗ ଆଉଟ୍
ଆଉ
ଅଲ୍
ଆଉ
ଦିସ୍
ଗୋଟେ
ଫ୍ୟାକ୍ଟ
ହଉଛି occurrence spot just occurrence spot
spot.
ଉପରେ the IO has no personal knowledge occurrence ଏଇ ଜାଗାରେ occurrence ହେଇଛି ବୋଲି it has no personal knowledge so unless it is brought through the evidence of the witnesses that somebody who had seen the occurrence like PW2 and 4 they pointed out that at this particular place the assault was made or he seized some bloodstain earth from some or something like that from that spot then it would be admissible otherwise it would be inadmissible the because he has no personal knowledge he has just ଏଇ ଯୋଉ ପୋଜିସନ ଗୁଡାକ ହୁଏତ ହେଇପାରେ ମାନେ ତାର ପର୍ସନାଲ ନଲେଜ ଥାଏ ଯେ ଏଇଟା ଗୋଟେ ରୁମ ଅଛି ଏଇଟା ତାର ପାଚେରୀ ଅଛି ଏଇଟା ବାଉଣ୍ଡରୀ ବୁଲିଛି ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ଇଟ୍ ଇଜ ହିଜ ପର୍ସନାଲ
Knowledge.
ଅବଜରଭେସନ ବଟ୍ ଏଇ ପର୍ଟିକୁଲାର ଜାଗାରେ ଘଟଣା ହେଇଛି ସେଟା ତା ପର୍ସନାଲ ନଲେଜ ନାହିଁ ତାକୁ କହିଥିବ କିଏ ନା ଅନ୍ୟ ସାକ୍ଷୀ ମାନେ କହିଥିବେ ଯୋଉମାନେ ଘଟଣା ଦେଖିଥିବେ ବା ଯଦି ହଁ ଡେଡ ବଡିଟେ ପଡିଛି ସେଠି ଗଲା ବେଳକୁ ରକ୍ତଟେ ପଡିଛି ହଁ ଏଇ ଜାଗାରେ ଘଟଣା ହେଲା ତେଣୁ ସେଥିପାଇଁ କୁହାଯାଏ ଯେ that evidence has to be adduced that how you prepare the spot map on whose statement you marked it as this is the place of occurrence this is the spot otherwise that spot map would not be admissible ତମେ ଗୋଟେ ଦେଖେଇଦବ ଏଇ ଜାଗାରେ ସ୍ପଟ ହେଇଛି ମାନେ you have no personal knowledge so it would be hit by section 60 of the evidence act ତମେ କାହାଠୁ ଶୁଣିଛ କଣ ଶୁଣିଛ କେମିତି ତମ knowledge ହେଲା ହଁ ତେଣୁ that is why ବର୍ତ୍ତମାନ ବି ସିଏ ଯାହା ଦେଖେଇଛି ଏଇଟା ଦେଖଉଛି ଯେ ପାଖାପାଖି ମାନେ ଡୋର ସାମ୍ନା ସାମ୍ନି ସେ ଘଟଣାଟା ହେଇଛି ତେଣୁ ମନେ କରନ୍ତୁ ଏଇ ବାରଣ୍ଡାରେ ଘଟଣାଟା ହେଲା ଜଣେ ଏ ଘରୁ ପୁଅ ଡାକିଲା ମା ରହିଛି ଏ ଘରେ ମା ଯାଉଛି ସେ ଦେଖିପାରିବ ଏଇ ଜାଗା କିନ୍ତୁ ଯେତେବେଳେ ଡୋର ବାହାରକୁ ଚାଲି ଆସୁଛି ସେତେବେଳକୁ ଆକ୍ୟୁଜ ପଳଉଛି ପୁଅ ସେତେବେଳେ ମା କୁ ଦେଖୁଛି ତେଣୁ ପୁଅର ଷ୍ଟେଟମେଣ୍ଟ ଆସିଲା ମୋ ମା ଯେତେବେଳେ ଆସିଲା ଆକ୍ୟୁଜ ପଳେଇଲା ତା ମାନେ ନୁହେଁ ଯେ ମା ଘଟଣା ଦେଖିବାଟା ସମ୍ଭବ ନୁହେଁ
ସେଥିପାଇଁ ଆଗରୁ ବେସିକାଲି ଯେତେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଏଇ ସ୍ପଟ ଉପରେ ଲୟର ମାନେ ଯାଇକି ସ୍ପଟ ଦେଖିକି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଏଇ ଜିନିଷକୁ ଅଣାଯାଏ unless you visit the spot you cannot cross examine the
cannot just
imagine
the way the councils were preparing we have seen it I have
my lord has experience in that
unless you discuss with the person and
Yes.
go to the spot see discuss is how it is possible kahinki eta hai nathibo kon hai nathibo you cannot frame the questions you cannot
unless it will go to the spot you cannot
the charm which a council get in successfully demolishing an eyewitness in the dock that charm will never even if you
That is-
argue 100 cases in high court and get the relief that charm you will not get that
and that is also art of the
that's
advocacy
okay any further submission Mr. So you mean to say that and if your version let us say Mr. Das if we accept your version also that PW2 came subsequently by that time the appellant was not there what
Lordship.
about PW4
PW4 minute.
why he would be dissuaded why his evidence would be
So far as PW4 is concerned, my lord, it is a child witness, and all I can submit is that such versions must be treated with caution, my lord. Must be dealt with
child
caution and
witness,
circumspection.
for that 118 of the evidence act says that he is a competent witness
Competent witness or not, that is to be
witness has been tested by
Yes.
the court the court has given a certificate that he is able to give rational answer. The court has declared him as a competent witness, right?
Yes.
So, no doubt, law says that the child witness are prone to tutoring.
Tutoring must be
So,
treated
there
with
is possibility
circumspection.
of that. But unless you bring something on record,
Nothing.
we cannot just imagine or visualize or hold that yes, he is a tutor witness, so his evidence is to be discarded.
Nothing in cross, my lord, to that light.
Because
Lord,
the question that has been put directly in paragraph number 4, it is not a fact that I was not present in my house at the time of occurrence. ତାକୁ ପଚରାଇଛି ଦେଖ ତମ ମା ତମକୁ ଶିଖେଇକିନି କୋର୍ଟକୁ ଆଣିଛନ୍ତି ଯୋଉଥିପାଇଁ ତମେ ବୟାନ ଦଉଛ ସେ ମନା କଲା ସେଥିପାଇଁ ଲେଖା ହେଇଛି it's not a fact that I have been tutored by my mother and for which I am deposing falsehood today in court.
Then, my lord, the next point, my lord, 5. 7 months prior to occurrence, my father had a cycle accident and had sustained a minor injury on his eyelid. That, my lord, in the last occasion also, I highlighted a bit. Some injuries could have been possible from this fall. But that there is no...
Which injury? The injury sustained by the deceased?
Sustained by the deceased.
But what about the age of injury?
6-7 months, my lord.
Please see the age of the injury as stated by the doctor. What he has stated? Has he stated that any of the injuries as possible 6 to 7 months back?
No, your lordships.
These are all fresh injuries, bleeding injuries. He noticed also.
Yes.
And fracture injuries, and he has stated. Cycle पढ़िकिनी injury ହେଇଥିଲା. Have you suggested it to the eyewitnesses?
No, your lordship.
Then
nothing is forthcoming from that. The evidences.
ଆପଣଙ୍କର ଯଦି ପ୍ଲିଜ୍ ଏଇଆ ହେଇଥାନ୍ତା ଯେ କିଛି ଇଞ୍ଜୁରୀ ଇଏ ହେଇଥାନ୍ତା ତାହେଲେ ପଚାରିଥାନ୍ତେ ୱିଟନେସ୍ କୁ ବାବୁ ଦେଖ ଯୋଉ କହୁଛ ମାଡରେ ଯୋଉ ଇଞ୍ଜୁରୀ ଗୁଡାକ ହେଇଛି ସେଗୁଡାକ ନୁହଁ ସେ ସାଇକେଲରୁ ପଡିଥିଲା ଅମକରେ ସେଇଥିରୁ ସେ ଖଣ୍ଡିଆ ଖାବରା ହେଇଛି ତାଙ୍କୁ ପଚାରିଥାନ୍ତେ ଆପଣ ପ୍ଲି ହିଁ ନେଇନାହାନ୍ତି ଆପଣଙ୍କର 313 ଷ୍ଟେଟମେଣ୍ଟରେ ସେ ପ୍ଲି ବି ନାହିଁ ନେଇଛନ୍ତି ଯେ
No. My lord,
it has also not been suggested to PW4
no.
that your mother was not there. She has not seen the incident. No suggestion to the certificate.
Whether the occurrence was at a blind spot, could not have been seen. Nothing, my lord, to that effect is forthcoming. My lord, I have a threefold proposition if I can sum up, your lordships.
Yeah.
Number one is that the evidence of PW2 and 4 are not reconcilable, my lord. That is
PW2 and 4
are not reconcilable, and hence the solitary witness of PW4 is to be taken into account, my lord. That is my point, proposition number 1, my lord.
No, cannot be reconciled means in what way?
By relying on that one line, if your lordship.
The moment he came, the accused fled out.
Yes. That's my sole basis, my lord.
PW reached the spot, this appellant fled away. So that is why there was no possibility on the part of PW2 to mark the assault. That is your submission.
Lordship. And this second leg of submission, my lord, would be that so far as PW1 is concerned, that is to be ruled out in totality, my lord. and cannot be relied on by the prosecution in a piecemeal manner in bits and pieces to infer the guilt of the accused.
That apart, PW4 has also stated in his examination chief that his grandfather, along with others, arrived in the spot later on.
Lordship. And my lord,
Where he has stated later on,
page 66. Page 66,
just let us see.
Ninth line from the top. Page 66, para 1, ninth line from the top.
Ninth line from the top.
At the time when my mother came to the spot, the accused pleaded away due to the assault. My father fell down so and so on the 10th line, sir. On hearing the hula, Pradeep Sahu, my grandfather, so and so, and others had been to the spot.
But in the cross examination, they have brought out that my grandfather had seen the incident.
But here again, he has said contrary to that and other persons so and so reached at the spot after hearing so and so. Though he stated in the examination chief that all of them came after hearing the hula.
Yes. Hence my submission, my lord, was
hearing the hula, so and so came to the spot. Again,
in para 2, page 67, he has cleared.
He has stated in they have brought out that he had seen the occurrence. That is how, even if somebody is coming at a little distance, he can see. So the moment they came, hearing the halla, he has seen that hearing the halla.
My grandfather had seen the assault made by the
on hearing halla. Hearing halla means my halla. Let us say.
Yes.
Hearing halla, they came to the spot. That does not mean that
he has not seen.
He has not seen. Because the halla started right from the beginning.
Beginning too.
And if we believe that these are the blows given, so the possibility
not one
other person.
But PW4 is also not stating that they were all there during the occurrence.
No, that
you have brought out in the cross examination
seen
that he had seen the assault. Who stated you to put that question in the cross examination? He has stated. That is why it is always said that defense counsel should know what not to ask first than what to ask.
It clarify.
जो जिनसो chief examination रे नाही ताकू जेरा करिकिनी बाहर करिवा एटा कोनोसी बुद्धिमान डिफेन्स काउंसिल रो लक्षण नुहे ये होची नंबर 1 हाँ तेणु सेथि पई कुआ जाय जे प्रथम आगे जानिबा दरकार आमे कोन कोन न पचारिबो आकु पचारला माने जदि कोन गोटे उत्तर देई देला पळी जिवो आम विरुद्ध रे इफ द विटनेस इज गेन्ड ओवर इट्स ऑल राइट चीफ एग्जामिनेशन ए जहा कोची कहू आस्ते किनी बाहर करी नै आसीबो जेरा रे तुरंत विदा करे दबो नले पुनी री एग्जामिन करी बाहर कर दबो से पुनी पब्लिक प्रोसिक्यूटर जदि क्लेवर हेतिबो तेणु तारो एटा को आपण बाहर करी आइले आपनकर जेरा रे
again my lord if will come to the if my friend completed so far the PW1 is concerned regarding his presence in the spot, my lord. I would like to present all other witnesses, those who have stated regarding the presence of the informant, the PW1. No, it's not required. We think because the PW1 during his crossing has clearly stated that I was not. No, I was not there. But only that one sentence, we cannot discard everything because in the affair, in the chief and other witnesses reach their spot
about his presence.
Cannot be told wholly denied, my lord. No, it cannot be ruled out that he was. He has said, but was not present. Under some circumstances, what question was put at the time, what does it type in? That is also be taken into consideration if others corroborate to the same his presence, my lord. Let me place one by one, my lord, evidence of the other witnesses regarding the presence of the PW1 in the spot on the spot, my lord. I would like to start from the affair, my lord. Affair, my lord, in the middle of the affair, my lord. Page 47, my lord.
Hmm. Hmm.
Middle of the my lord, the ଲକ୍ଷ୍ମୀଧର ସ୍ତ୍ରୀ ଏବଂ ତାର ପୁଅ ବ୍ରଜ ଦେଖି ପାଟି କରିବାରୁ ପଡୋଶୀ ମାନେ ଘଟଣାସ୍ଥଳକୁ ଆସିବାରୁ ହରିଶ ଦୌଡ଼ି ପଳେଇଗଲା। ମୁଁ ମଧ୍ୟ ଏଇ ଘଟଣା ଦେଖିଅଛି। This is one thing, my lord. Next, my lord, I will come to evidence of PW3, page 63. Third line. At that time,
PW3.
my lord, page 63, third line. At that time, I was in my house. The informant raised halla by saying, "Dhahi aso," and on hearing such, I had been to the spot. Means after seeing this occurrence, my lord, he also raised halla, the informant. So,
but PW4 said, I boulo maridala.
PW said first, exactly, he stated first initially, but he is the first witness who saw the assault. Thereafter, others, the wife and the grandfather, there is, because the statement of the PW1 is that on the halla of the grandson, he went to the spot. Now, my lord, again come to the PW6, my lord, page 70. Para 1, line 3. On hearing the halla of Gananath Raut, I had been to the house of Lakshmidhara Raut and found the deceased lying on the floor, sustaining bleeding injury. This is the PW1 matter, Gananath Raut. And on thereafter matter, on being asked to the Gananath, the father of the deceased, he disclosed before me that the accused had assaulted the deceased. Means he was very much present in that spot matter. Next to my lord, witness PW7, my lord, page 72. 6th line, my lord. At that time, the informant, namely Gananath, saying that the accused had assaulted the deceased. Immediately thereafter, myself and Jagannath taken the deceased to the hospital, my lord. So we cannot say that on one line he has stated that
cross-examination
that all the evidence of the we don't already discarded, my lord.
PW7 is.
He might be saying that accused assaulted the deceased. That doesn't mean that he was present. It cannot be.
No, because he, on the hearing of the halla of the PW1, other witnesses reached there.
They have seen the presence
of the witness there.
And which he has also stated in the chief examination.
Yes, my lord. And also in the affair. And also the PW2, my lord, he says also in the cross-examination.
Which one, Mr.
PW2, my lord.
PW2, yes.
The mother, my lord, wife. The occurrence took place in the month of December. I cannot say whether the fortnight or the moonlight. My father-in-law reside in village Dhanuria with the accused, and on the date of incident, he was very much present in the village Dhanuria. So we cannot only take the one question put by the summary answered, they are not present. With all the witnesses and the affair and the evidence, and also in the cross-examinations, whatever they try to brought out, my lord, everything says that the presence of the PW1 is on the spot. And the evidence of PW1, 2, and 4 is consistent. The defense has not brought out anything that the evidence would be discarded, ma'am.
No,
Not to
PW number 1 being the father of the accused. Is there any evidence that all of them were residing together? Though admittedly the accused
No,
and the deceased person, they
are different.
neighbor.
And the spot my will see the that there is a boundary wall between the the accused and the
house of accused and the deceased.
because they are brothers.
Maybe, but is there any evidence on record that PW1 being the father of the accused, also the deceased was staying with them,
With whom, my lord?
either with the
With the
accused
accused, my lord.
or the deceased?
That is the evidence of the PW2, my lord.
No,
Because
she has not stated that my father-in-law was residing with
With the accused.
she's saying that.
resides in the village Dhanoria.
My lord,
With the
kindly,
accused.
with the accused.
So that line, Mr. Das.
My lord, PW,
Para 3, page 62.
62.
Procession by the defense.
Paragraph 2 रे कोई my
Para 3
father-in-law resides with the accused in village Dhanuria. So that
page 3,
62, my lord, para 3, last line, my lord.
you can say that my father-in-law.
see after saying my father এটা भी বলছিল
আগে
my father-in-law resides with the accused in village Dhanuria.
আগে
Again কৌছি যে my father-in-law resides in village Dhanuria with the
With the
accused and
accused.
on the date of offense he was
He was
very much present in so and so.
village.
हाँ মানে সেই ଗାଁ ଗାଁ
ଆଜ୍ଞା।
ତ ଏକା ଆଉ ଗୋଟେ ଗାଁ
So they goes sometimes on being called by the friends of my father-in-law had been to village of Partha, sometimes, not on the date of occurrence.
ଯାଉଥିଲା ସେ ଯୋଉ ଅପର୍ତ୍ତା ଗାଁକୁ
Right.
କିନ୍ତୁ ଅଦରୱାଇଜ ସିଏ ରହୁଥିଲା ଏବଂ ରହୁଥିଲା କୋଉଠି ନା ଆକ୍ୟୁଜ୍ଡ
Correct.
ଘରେ ରହୁଥିଲା ଏଇଟା ହଉଛି ତାର PW2 ର ଏଭିଡେନ୍ସ ଇନ୍ ଚିଫ୍ and also in the cross examination. That Mr. That weapon of offense was, of course, not shown
produced.
to that PM doctor, but it was shown to the doctor who first treated the deceased.
Because
The right. The doctor.
PMA is conducted at the Katak Mail ACP.
Right.
That's it.
And no, that's a different part, but the it has not been marked as a material object.
Memo not produced.
He was Mr. Das was pointing out that any further submission from Mr. Das or
No,
yes, Mr. Das, any citation, any further
Yes, Your
submission?
Reliable. Three decisions, my lord. The settled propositions.
On what point? First tell me and then say.
Lordship. 2017,
Hmm.
11 SCC.
11
One-
SCC?
195, page 195.
Yes. On what point you
Rely
are
on-
placing that dissent?
On the testimony of inimical witnesses, my lord. How they are to be considered with
Which is the
circumspection.
relevant paragraph?
24 and 25, your lordships. 24 onwards. 24 to 28.
Hmm.
As your lordships pointed out, that the principle of the double-edged sword can be a ground for false implication. But however, evidences must be produced to that light, my lord.
Hmm.
That, my lord, I failed to because
Hmm.
my lord, the second decision is
Hmm.
1973 volume 2 SCC page 808.
19.
73
Yes.
volume 2 SCC
Hmm.
808.
Paragraph.
25 and 26, my lord.
Hmm.
This is on the proposition, my lord, when there are two views possible, my lord. The view favoring the accused must be resorted to, my lord. That
This is it a case of must be a case of acquittal in which this observation made. Two
logic.
views means what? The appreciation of the evidence.
Because
That,
my
1 plus 1 so 392 is the offense committed. Law session is convicted on appeal, admitted. Then the accused came across one so specially. Okay, which paragraph? 25.
5 and 26, my lord.
Please place it. Let us see that.
My lord. Another golden thread which runs through the web of the administration of justice in criminal cases is that if two views are possible on the evidence adduced in the case, one pointing to the guilt of the accused and the other to his innocence, the view which is favorable to the accused should be adopted. Here, my lord, definitely there is no evidence pointing to his innocence, but was my endeavor was to buttress on this fact that probably the blow was singular. No evidences are stating in their depositions that there were multiple blows, that successive blows were dealt one after the other. But my lord, however, the medical examination and the statement of the doctor who has examined the body, my lord, says otherwise. That, my lord, I bow down to. It's just a proposition I am laying before the court, my lord.
No, let us see the Mr. That a doctor who first treated the
That is not there, my lord. No evidence is forthcoming of that doctor who first treated.
no this that CHC doctor you placed that one doctor who examined that weapon of
Schedule
offense.
9,
9. 9 and 15, there are these two doctors have been
No,
examined.
15 is that PM report.
Yes.
Bodasai Hospital CSC is the first where he was treated,
Treated.
right?
Yes.
And the report has been marked as one so,
Registration number such and
and
such.
he stated in paragraph number 2 that he found that the lacerated wound on the temporal region might have been so, and exhibit 4 we are also just verifying it again. 4 টা বার করলে exhibit টা করালা। In exhibit 4 also it is mentioned
Yes.
that NB means note below. Lakshmidhar was admitted to Bodosai CSC on 9/12
13.
2014 13 बोले
13 से
13 हाँ
आगे
at 8:30 p.m. following injury to the that is head injury तार नंबर दिया है जो ये नंबर registration number दिया है 4891 and he was referred बोधे perhaps referred to DHH
बारीपदा
बारीपदा की हाँ मे बी सेटा कोउठी लेखा ही था ऊपर so that means 9th he came at 8:30 he was admitted registration was made and then he was referred uh, uh,
to district
to
headquarter
हाँ and that is how on 10 तारीख दिन
हाँ आगे
रेफर ହେଇଗଲା ଏଠିକି 10 ତାରିଖରେ ସେ DHS କୁ ଯାଇଛି ତାପରେ କେବେ ଗୋଟେ ଆସିଛି SCB କୁ SCB ରେ ତାର ଡେଥ୍
Death
ହେଲା
age।
ପରେ ଯାଇଛି this is the
13 तारीख डेट थी
हाँ
but my lord all I am trying to
yes
argue is that the act was not a premeditated act, my lord. There could have been no intention because of the nature of weapon used. Had it been so, he would have come with something more blunt. Though there are no evidences forthcoming to that effect, my lord. But definitely something has happened in the background prior to the dealing of the assault.
that
That is no, there is no evidence, my lord, no
no,
attempt also
he-
made from the defense side to bring that to light.
ତାର ସେ ଯୋଉ ବାଡିର ଯୋଉ ମାପଚୁପ
ଆଜ୍ଞା
ହେଇଛି ସେଟା please see that କେତେ ବଡ ବାଡିଟା ସେଇଟା ଆପଣଙ୍କର ନୁହେଁ ଯେ ଏଟା ଗୋଟେ ଯୋଉ ଛୋଟିଆ ଇଏଟା ତାର ଲେନ୍ଥ ଟା ଦେଖନ୍ତୁ ଆଉ ଇଏଟା ଦେଖନ୍ତୁ
my lord 104 ରେ page
ଏଇ 102 ରେ ଆଗେ ଦେଖନ୍ତୁ ସେଟା
ଆଜ୍ଞା
ଯୋଉ ପଠା ହେଇଛି ନମ୍ବର ସିରିୟଲ ନମ୍ବର
yes
3
yes
ଆଉ
I'm
4
so sorry yes my lord
ତାର ସରକମଫରେନ୍ସ ହଉଛି 3 ଇଞ୍ଚ
3 इंच
ରାଇଟ
ଆଜ୍ଞା
ଲେନ୍ଥ ଟା ହଉଛି 10 ଇଞ୍ଚ କି କଣ ସେ ବୋଧେ ଆଉ ଏଇ ଯୋଉ ଆଉ ଗୋଟେ କଣ ଲେନ୍ଥ ଟା ହଉଛି 3 ଫୁଟ ସରି 3 ଫୁଟ ଦେନ୍ ତା ଦେହରୁ ଭାଙ୍ଗି ଯାଇଛି ଆଗରୁ ଉପରୁ ଭାଙ୍ଗିଛି ସେଇଟା ବି ମଧ୍ୟ ଦେଖେଇଛି ସେ
and after 3 days of the occurrence, my lord, it has been seized. Something which is normally found, my lord, in a village environment. କୋଉଠି ପଡିଥିବ ଆଣିକି so something has happened prior to that that erupted between the two, but the grave sudden provocation of material କିଛି ନାହିଁ to argue
where
with.
from this stick was recovered
From that incident
whether it was
spot.
lying at the spot
Yes, from
or it was recovered at the instance of the appellant.
no, your lordships, it was found at the spot.
Who has stated that?
My lord, if sees page 77,
Yeah.
I know the informant, deceased and accused present in the dock in connection to this. The IO had seized on 12/12/13 in front of the house of the accused 2 broken pieces of 1 lathi.
In front of the, not in the courtyard where
Yes.
the incident occurred.
Near the spot somewhere in front, it says in front of the house. In front
The
of the
incident
house.
occurred when?
Incident 9th.
9th
So after 3 days.
after 3 days.
Because the FIR was lodged on 12th. If they were trying to save the life of that man, that deceased, he was going from one hospital to other. First in that Bodosahi or something, then it Baripada, then to SCB. Katakre death ହେଇଛି 12 ତାରିଖରେ ନା 13 ତାରିଖରେ ବୋଧେ ଡେଥ୍ ହେଇଛି ନାଇଁ 13 ତାରିଖରେ ଡେଥ୍ ହେଇଛି କାରଣ 12 ତାରିଖରେ ଯେତେବେଳେ FIR ଲଜ୍ ହେଇଛି at that time it was a case under section 307 and that is how in the charge it is mentioned that the death took place on 13/12/2013. So it is almost after 4 days the death has taken place.
Yes. No intention as such, my lord, can be
No,
attributed.
how a intention can be gathered? If you assault on repeatedly on a vital part of the body and the impact of the blow is such that it has caused
Caused
fracture on the temporal region and even that stick was broken to two pieces, can it not be said that it was with sufficient force that blow was given on the vital part of the body, which is one of the factors to show that whether what was your intention?
Lodge.
Depressed comminuted fracture of size so and so, that is the evidence of the doctor.
Yes. 15. PW 15.
Hematoma was noticed on the whole of the left side, back of the head. Left temporal muscle was found to be contused. Depressed fracture on the left parietal eminence, which gave rise to feature fracture. Extradural hemorrhage was there. Punctured brainstem hemorrhage was seen in the punch and medulla. Surrounding brain tissue was necrosed and friable. The base of the skull was also fractured on the left side. That is how he has given the opinion that it is caused by so. Death was due to craniocerebral injuries and complications thereof. Okay, this is the second edition. What about the
And
third
the
one? You
last
said?
one, my lord, on the child witness.
What
The
is
evidence of the child witness must be,
reference?
Lordship, it's 1998, volume 7 SCC, page 177. 77, my lord.
Which
is
paragraph?
11 and 12, my lord. Well settled position, my lord.
See.
Though, my lord, it cannot be negated in totality in all cases when it finds corroboration. Must be treated with caution.
No, that's certain.
Lordship. That's all, my lord.
It is not the law that if a witness is a child, his evidence shall be rejected, even if it is found to be reliable. The law is that the evidence of a child witness must be evaluated more carefully and with greater circumspection, because the child is susceptible to be swayed away by others, tell them, and that the child witness is an easy prey for tutoring. That is the courts have laid down the evidence of child must find adequate corroboration before it is relied on. It is more of a rule of practical wisdom than of a law. Yes, so that's all.
Yes, your lordship.
Mr. Das, anything further? Just for the- Das and counsel for the appellant, Mr. Arupanand, an additional government advocate. Mr. Das has filed some citations which have taken on record. Hearing is closed, judgment is reserved.
We are extremely grateful, my lord, for your lordship's patience.
Citations were kept on record. Yes.
Grateful.
Anybody else is present, Mr. Bharat?
एशिया 26 जो ଥିଲା ଆଉ ଗୋଟେ କାହାକୁ alert update ଗଲା
Item number 26.
ସେଥିରେ ପ୍ରେମ ପଟ୍ଟନାୟକ ଆଗରୁ ଥିଲେ expired, someone should be engaged.
Item number 26, Prem Patnaik. No, if Mr. Dhwal is there, so if one of his associate who has already must have prepared for Tuna Sahu,
Yes, ma'am.
if he is engaged as Tuna Sahu, provided that he has got the practice of 10 years, then he can do both the matters.
Right.
26 ସେ ଡିପି ଧଳଙ୍କ ଚାମ୍ବର ଗୋଟେ ଆପେଲାଣ୍ଟ ପାଇଁ ଅଛନ୍ତି ଆଉ ଗୋଟେ ଆପେଲାଣ୍ଟ ପାଇଁ ପ୍ରେମ କୁମାର ପଟ୍ଟନାୟକ ଥିଲେ is now dead. So if we engage any of the counsel from DP Dhal's chamber as amicus curiae for Tuna Sahu, then argue both the appellants. So where is that? Anybody from DP Dhal's chamber is there?
No one is there.
What about the 24 Dipali Mahapatra, then and 25 Miss Tapaswini Sinha?
25 ଟା ସରିଗଲା 25 ଟା ପାଠାଡିକି ଅଛି
କେବେ ରହିଛି?
ମଣ୍ଡେ କୁ
8 ଜାନୁଆରୀ ଅଛି
ପାଠାଡିକି ଅଛି।
ଓକେ କୋଉଟା 22 ଫାଷ୍ଟ ଓଭର କଣ ପାଇଁ ହେଇଛି?
କୋଉଟା
D Mitra, item 22.
24.
D Mitra means I think criminal bar room na? ଆପଣ କହିଥିଲେ ବୋଧେ ତାଙ୍କୁ ଜଣେଇ
ଆଗରୁ ଥର କହିଥିଲେ ଆସିଥିଲା ଏବେ ଆଉ
No, it's the problem is that if they don't turn up,
No,
somebody
we
else.
should engage, my lord should engage.
ओकरा नाम फाइल करछन्ती न आसिले एंगेज टू बी डन तो तांको संगे तांको जोगाजोग हेलानी कोन कहले से को दिन कहले
नहीं कटक किमना बार
I think he was an associate of
आगु थिला
देवस्नान
हां देवस्नान तो मजे सूर्यवंश में भी था
हां राइट
दीपल मत डाक पुट्टे
तो where is that list से जो अपन बार नहीं कि से अमाइको सिक्योरिटी रो लिस्ट जो दिया है अपन
पास करते डे करथिला ना कोन
कोडा नहीं से मैटर जमा आरंभ है दीपावली महापत्र मैटर आरंभ
डाकली 24 टा 25 टा डाकली और ना की डाकली
My lord.
Respondent is dead. When respondent died, respondent for death certificate is enclosed. Respondent have been informed that a will be taken of the respondent, so on, so on, so. Court order. So it is Mr. Devashish Panda is to do this case.
My lord.
So just ask Mr. Panda or Mr. Sudipto.
My lord.
And do you know this item number 33 council को? Nalini Kumar Pandit की, Nalini Ranjan Pandit.
Nalini Ranjan Pandit.
एटी का practitioner ना हो कोड कर.
35 टा भी गवर्नमेंट रो.
35 सब गुड़ा गवर्नमेंट अभी.
आगे.
एटा गंगाधर त्रिपाठी ना डिलीट हबो but की करिवो तांकर. Mr. Jali's name is there. देखी GCRL 4 टा देखी कौन है.
कोर्ट.
पेपर बुक टा धर ले तो. पेपर
Aye.
बुक अच्छी तो हाँ. बड़ा अच्छा ना.
Back.
뭐가 안 돼, 있더라지. 오, 89 거. फाइल तापरे ये मगे दो ट्रायल कोर्ट रिकॉर्ड. It's a dowry death case, Mr.
Yes, Miller.
Mr. Ponda is coming.
Hmm?
Mr. Devashish Ponda is coming.
क्या ये तो ये रिपोर्ट से गोलानी खोला से की दिए देना
कल हमें तो अच्छा होगा.
हमें अच्छे ऑपरेटर
हाँ.
जाओ
वही प्रेम लगाओ.
It has to go to some.
I have two matters. They should go to some
No,
other.
no, that's all right. I was just told so. This is item number 34, and another one is
Another one is yes.
Yeah, what is
Another is a criminal appeal. See, 47.
40, 47. Dita ka matter likhi deben. Put up this matter before some other bench in which one of us, Justice S.K.MISHRA, is not a party. No? 34 and 47.
47 dita 34 47 47 लगा
Yes. So ये किसी मिडिल है कि मिस्टर ये
kind of लिखित 47
आइटम नंबर 35 टाकू कहिबे मिस्टर जाली जदी करथिबे ते
आगे
गंगाधर त्रिपाठींकर चैम्बर केस की करछंदी वर्तमान एंड देन नेक्स्ट मैटर इज ललाटेंदु सामंतराय
हाँ तांका चैम्बर अछन
एटा एसडी दास में चैम्बर की ये चैम्बर
आगे
38 Vasudev Pujari is there.
I can inform for next week my lord.
डीपी धवन को खबर दे लगी थी
आगे जेसीआर जोटा 26 टा जोटा प्रेम पटनायक रो एक्चुअली मु कथा दे हम मिस्टर महांती पाखरे सब ब्रीफ सब तांका पाखरे अछि
करना थी
सो आज से एक करना जदी कहबे कर देबे
नहीं एंगेज कर
और
देबी
एंगेज कर
जदी डीपी तांको सेटा तांको एंगेज कर दो डीपी धवन को तो सेटा रेगुलर अपील हां से करिवे किछ असुविधा नहीं so let him come Mr. धौल और मिस्टर परिडा जी भी आसिले
मैं दासपेड़ा फोन करतली
him, your lordships. I was doing some other matter. I heard it.
Uh-huh.
I called him up and I asked him to be
Okay.
present.
Ask him at least send one of the associate to remain present so that it can be, if he's not
Yes,
today in court. So
yes, your lordships. कुछ नहीं किया सर एडजर्नमेंट लिख देता हूँ मैं
hmm.
I have informed him, your lordships.
We are waiting, Mr. Naik. Just
Yes, your lordships. Yes.
Mr. Naik, please come. So about 40% of the cases listed for hearing is of three chambers, as we find. Your chamber, Mr. D.P. Dhal and Mr. D. Panda. And D. Panda case cannot be argued here because my esteemed brother is concerned. So I find that at least from this list, 3 to 4 matters are there of your chamber. So, and these are of the matter of 2003.
I know.
So get ready so that it can be
Yes,
taken
ma'am.
up next week.
So next weekend.
Ah.
Yes, ma'am.
And
But
please intimate the bar members that these are all old matters. We are sitting right from
today there
11:55.
is a problem, my lord, I had. I do not know exactly. The display board, my lord, wrong showing, not working. 24 ଦେଖଉଛି ବୋଲି ଆମେ ଦେଖିଲୁ 33 ବୋଲି ମୁଁ फोन पाइली और बहुत दौड़ी गए 24 चांद खड़ा तापर और खाइबी
These are all 2001 2001 ଦୁଇଠୁ ଆରମ୍ଭ କରି ଏ ଟାଇପର ଇଏ so we don't want to just cancel the bail and all these things.
I
We
will
don't
get
want
ready.
to adopt that.
And today I will also intimate in the bar. Man, there is a meeting in the bar. I will also intimate.
At least ଗୋଟେ criminal appeal ବି
Aye.
and it's a we hope that from next week
Yes,
onwards.
man. Yes, man. As sure.
Yes, all right. Thank you. Mr.
Item 36, my lord, that is not our office file is not. Because in the file of senior advocate Mr. S.D. Das,
It's not of Mr. Samuntrai.
Yes, all the powers are S.D. Das associated.
No, then please intimate Mr. Das
Yes,
that
sir, I
at
will
least he
intimate.
should send one of his associate or he himself to argue the matter.
I will intimate.
All right. So, Mr. Das, we are rising. Or there is
Yes.
one thing can be done. There is a noting that my single bench can function
After
either
rising
at
of
2
the
o'clock or after rising. So, whichever is earlier. So, I can take up if the councils are present from the.
today
Today is not possible.
later.
All right.
$695 of 2023. I pray for listing next week.
Give the memo.
Yes, ma'am.
Your Lordship, item 36 may be taken up tomorrow.
No, I will go serially.
May I pray, so 159 minutes. Item 150 can be taken up, Lord.
We'll see that.
Yesterday, Lord, I have mentioned your Lordship directed to listed
Okay.
today. My Lord.
Pardon me, my lord. My lord, CRL 463/18. Accused in since custody, accused in custody 2015, my lord. So kindly for bail.
Give it.
Your Lordship, item
How many
150
memos I have filed?
item number 60.
Just a minute. Six zero. 4179 of 2023, right? You are filing the memo. Mr. General and Counsel for the petitioner files a memo for withdrawal of the VLAPL disposed of as withdrawn. Yes.
Your Lordship, item 127 is the only main application for interim bail on the health grounds of the accused petitioner, Lordship. Before vacation, it wasn't listed due to paucity of time, could not be reached. Lordship, kindly taken up today, Lordship.
Instruction has been taken.
Yes, already
Wait till
127.
It's an appeal. I mean, out of 7 years, I am frustrated for more. Give it.
Item 129, Lord. Interim application is pending. Last occasion also. Interim application. Interim bail application is pending. Lordship Director, last occasion of giving the copy to the
Is it in the list today?
Yes. 129 serial.
Okay. Yes.
Pardon me, Your Lordship. In CRLA 443 of 2014, Your Lordship, we have pardon to list this matter on next week, Your Lordship, for early hearing and preparation of paper book.
Early hearing of the?
Early hearing of the CRLA and preparation of paper book, Your Lordship.
Okay. So you have prepared the paper book?
No, Your Lordship. We have filed the IA for preparation.
You are ready to prepare the
yes,
paper?
Your Lordship.
What is the year of that appeal?
Sir?
What is the
Your-
year of the appeal? Which year of the
2014, Your Lordship.
2014?
Yes, sir.
Paper book has not been prepared yet.
No, Your Lordship.
All right, give it.
Pardon me, Lordship. Lordship, BLAPL 8027 of 2022. Lordship had directed to be tied up with 7980 of 2022. And that matter has been there in the list in item number 39. But this matter has not been tagged.
Okay. So tag कर दो लेकिन who is the you are the counsel in the matter which is in the list.
Yes, Lordship.
Then you are to just mark it so that it can. Okay. Yes.
Lordship, last item of today's list, Your Lordship. One modification, Lordship. Typographical error has cropped up in the order. Order dated 19/12/23, Lordship.
देखिए WhatsApp 174. order tower. What is to be modified, Mr.?
Lordship, the description of the conviction.
Yes. Yes. कौन है कौन?
Lordship, the appellant petitioner is convicted and has been a period of 1 year and to pay a fine of rupees 5,000.
Yes.
That has been written wrongly. He actually convicted for 1 year and to pay a fine of 3,000 and undergo for a period of 1 month. That has been typed as 1 year, Your Lordship. And to pay a rupees 5,000.
All right. It would be done.
Obliged.
Pardon to mention, my lord.
Are you disclosed for the?
My lord, I'm
Rinkanal, VC.
Yes.
My lord, may I mention IA number 2 of 2024? My lord, this is a IA for suspension of sentence in jail criminal appeal 109 of 2022. My lord, out of 10 years of imprisonment, the petitioner is already undergone more than 8 years. My lord, kindly list this.
Madam, please tell the JCRL number.
109 of 2022, my lord.
IA number भी लिख दीजिए. All right, it will be listed next week.
All right,
my lord, BLAPL 10967 listed today as item 137, my lord.
What do you want?
Sir, it may not reach today, so it may be listed on Monday, my lord.
No, Monday there is a different list. So this type of matters will come on Friday. So if you have difficulty, we can keep it to next Friday, but not on Monday.
Sir, I am ready today, my lord.
Ready today? Then wait. I am going serially.
Oblige, my lord. Oblige, my lord.
I may be pardoned, my lord. The petitioner argued Mr. Senior Advocate Mr. Moon yesterday. He has been dismissed from service.
Okay, just
on the day before yesterday, I filed the memo with enclosures.
ଏଟାକୁ ସେ ଯୋଉ କାଲି ଗୋଟେ order
ଦେଇ ଦିଅନ୍ତୁ
ଥିଲା
ବୋଧେ।
ତାକୁ ନେଇକି ରଖିଦେବେ ତାଙ୍କୁ କପି ଦେଇ
କପି
ଦେଇଛନ୍ତି
ଦେଇ ଦେଇଛି ତାଙ୍କର ବି ରିଟିନ ନୋଟ କପି
Copy has not been served the petitioners. Order dated 3/1/2024.
हाँ
3 तारिखରେ dismissal order ଟା ହେଇଥିଲା ଇଏ
whatever it may be. I asked him to obtain the instruction whether he is still in service or dismissed. The information has been given that he has been dismissed and with the copy of the order. And you are supposed to file a written note.
Yes.
Did you file it?
Yes, copy has
Today-
been served.
today-
All right. Hold the minute.
Obliged.
Yes, I may be finding yearly, if possible, the yearly hearing matter.
Which matter?
This matter.
You have argued the matter for stay of conviction.
Already
The order is reserved. So you are anticipating that it will go against you. I couldn't follow it.
already dismissed the service, that is why.
You argued the matter not on merit but on stay of conviction. So let that order be first pronounced. Then you can make your application for expeditious hearing. It can be some order. The matter was heard yesterday at length and it was reserved. Wait till the order is pronounced. Yes.
Supplemental list item number 1.
May I please?
Yes, Mr. Roy.
Well, it's a case under section 20B, 2C and 29 of the NDPS Act. Allegation is, my lord, the police personnel got an information that one nursing being conspired with other associates, namely Subhas, this petitioner, Rajo and MD Hafiz, and few others were trying to transport some contraband articles.
It's a
When
case
they
of seizure of commercial quantity of ganja.
22 kg, 160 gram, my lords.
Whatever it may be. So, but why anticipatory bail you have filed?
My lord,
you surrender and move for bail, it will be considered if co-accused been released on bail, that can be also taken
all
into
the
account.
co-accused person have been granted bail, my lord.
Yes.
All the co-accused person have been
All right,
granted bail.
I'm noting down it. Are the learned counsel for the petitioner and counsel for the state, in view of the commercial quantity of ganja seized in this case and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail, it is observed that in case the petitioner surrenders before the learned court below, that is additional session judge cum special judge Gunpur, in TR case number so and so, which arises out of so and so, and moves on application for bail, the same shall be disposed of expeditiously, and claim of parity with the co-accused persons who are stated to have been released on bail will be taken into account in accordance with law.
May I pray Tufan Singh judgment may be reflected.
Yes.
Tufan Singh's judgment may...
that you place there, the learned session judge can take into account. Yes, next.
Okay.
Yes.
Item 2.
May I please? 294, 323, 325, 30.30, 341 and 56, my lord. Allegation, my lord, some fill the language and assaulting the lathi and iron.
Earlier you approached this court.
Yes, my lord. Under page 12, answer 2, the similar putting Guldi Singh, his religion bail.
But I have rejected your bail application because there is a grievous injury on the head.
Thereafter, my lord, page 12, my lord.
Page
12. Guldi Singh and Sampon is similar putting it.
Where is the statement of that injured? If you claim that you are similarly situated, you are to produce the statement of the injured because he is not having the case diary with him. Have you got the injured statement?
No.
To produce that, otherwise it has to be adjourned to some other day to give him opportunity of producing the case diary. It appears that the earlier bail application of the petitioner in ABLA PL number 2444 of 2021 has been rejected as per order dated 15/2/2022. The learned counsel for the petitioner submits that similarly situated co-accused, namely Goldie Singh alias Harjit Singh, and others have been directed to be, and others like Dilipra, and others have been released on bail by this court as per the order dated 28/7/2022 in ABLA PL number 2829 of 2021. The learned counsel for the state submits that he is yet to receive the case diary and to verify the claim of parity, and এটা আসন্তা সপ্তাহ আনিবি কি কোউ থানা এটা
Rajgam.
So put up this matter on 12 তারিখ রাখি দিন 12th of Swan. Yes.
No interim.
আসু 12/1/2024. Yes.
Bar done.
CDB obtained in the meantime further. CD along with CA. Okay. Yeah. Next.
Item 3.
May I please, Your Worship? Allegation under section 20B2C NDPC Act, madam. Seized of 20 kg contraband ganja.
Commercial quantity is there.
Yes, madam. Yes, madam. Petitioner is the driver, madam.
Okay. Surrender move for any co-accused has been released on bail.
All other co-accused.
Okay. Say pratham order bhaya likhi debe. Hala. All right. You surrender claim of parity to be taken into account. Yes. Next.
Item 4.
My pleasure. Both the petitioners are
6.
Yes, item 6, Your Lordship, on behalf of Divedi, it's the comprehensive affidavit I have filed. Behalf of Sujya Divedi, comprehensive affidavit I also have submitted. And also, government is. Also, let it come on next week that it is mentioned that SR not made. Why? Oh, defect number 13. What is that defect? Not properly indexed. Okay. So you remove the defect and because now you have to remove all the defects. So let's take down the Land and Council for the petitioner files. What you have filed? Comprehensive affidavit which is taken on record. It seems that SR has not been made because defect number 13 has not been removed. Land Council for the petitioner submit that they said defect will be removed by next week. Put up the matter immediately after the defect is removed. It's a case regular bail application. You have
20B2C. 20B2C.
You have obtained your case diary.
Yes.
The Land and Council for the state submit that he has received the case diary. So remove the defect number 13. Sure. Yes. Next. Publication.
Item 7.
Chip, item 7 may be disposed of as withdrawn, Your Lordship, as the trial has reached its fag end.
This Bini Mistral and Council for the petitioner seeks permission to withdraw, as in the meantime, trial has been concluded.
Your Lordship, it has reached its fag end. It has not been
trial has reached its fag end. In view of such submission, the BLAPL is disposed of at as withdrawn. Yes, next.
Much obliged.
Item 8.
Please, Your Lordship. It's a case of 302, my lord.
CD required, my lord. CD is not.
Fresh matter?
Yes, my lord.
Okay. State Council seeks some time to produce the case diary. Gote saptah pore shukrobar dino pakegi. Yes, next.
Great.
Item 9.
CA and CA kar diya.
And my lord, here for interim bail, my lord, on the ground of illness of the father of the petitioner.
This bail application is itself a prayer for interim bail.
Yes.
So it is coming for the first time. Have you obtained instruction?
No, no, first time it has come.
Okay.
But this petitioner having 17 criminal antecedents.
Okay, I am indicating that.
Yes.
But also you take instruction about the ground which has been taken. Which paragraph you have taken, Mr. Mahanti? That is okay. Some medical documents have been given. All right. All right. This bail application is for interim bail on the ground of ailment of the father of the petitioner. Medical documents in connection with such ailment has been annexed to the application. Land Council for the state seeks some time to obtain instruction. However, he further submits that the petitioner has got as many as 17 criminal antecedents. Let the Land and Council for the petitioner obtain instruction about the status of those cases and file a comprehensive affidavit to that effect. Put up this matter on such and such date. Yes, next.
Another connected matter is there that has not been listed. You also may direct that.
This item number 10 is also same.
Same matter.
Okay, 9 and 10 order same kar debe.
Another matter, my lord.
9 likhi debe. Land and Council for the petitioner submits that another connected matter of the petitioner is sub judice before this court in BLAPL number
13946.
13946
of
of 2023. ठीक तो? Okay, it will be listed together. Yes. 13946 of 2023.
Item number 11.
Mr.
May I
Panda.
please? It's the Belgium matter. The petitioner arrested on 23/6/2023. Earlier in bail, the annexure 2, page 14, madam.
Yes, Mr.
Yes,
Tripathi.
madam.
Are the Land Council for the petitioner, Land Council for the state, Land Council for the petitioner submit that the petitioner was on bail. However, due to non-taking of steps on the date fixed, non-bailable warrant of arrest was issued against him, by virtue of which he was taken into judicial custody on 23/6/2023. Baki Belgium format triple allow कर दो. Yes, next.
Item 12.
May I please, your lordship? My lord, petitioner inside custody, my lord.
Yes, area available.
No, madam.
Press matter.
Yes.
My lord, co-acted person granted bail. Lordship.
Associate
So,
395 criminal antecedent and
only one antecedent regarding the same cases.
CDCA. Next.
Okay.
Item 13.
Mr. Das.
My lord, Belgium matter, my lord. Petitioner was earlier on bail, my lord. Subsequently, warrant has been issued, and in the meantime, now is in custody since 12/7/2023.
କେବେଠୁ ରହିଛନ୍ତି ବର୍ତ୍ତମାନ?
ବର୍ତ୍ତମାନ 12/7/2023.
12/7/23.
My lord.
ସେଇ ଟାଇପ ର ଫର୍ମୁଲା ସେଟା ପକେଇ ଦେଇ ବେଲଜିୟମ କରି ଆଲାଉ କରିଦିଅ. Yes, next.
Item 14.
Please, your lordship. Lordship, the petitioner is in custody, my lord. 25th of November
15 and 15.
2021.
Both case copy not served.
Mr. Mahapatra, the Land and State Council submits that you have not sought the copy of the bail application on him.
Copy service ହେଇଥିଲା.
Make necessary arrangements so that it can come next week.
Yes, my lord.
Okay, Land and Council for the state submit that he has not received the copy of the bail application. Mr. Lakshmidhar Mahapatra, Land Council, appearing through the virtual High Court Bhubaneswar, submits that he will supply the copy of the bail application along with the annexures to the Land Council for the state by next week. Put up this matter, give a date. Is both these matters. Item number 14 and 15. Yes.
15, my lord. 15, my lord. This matter, similar matter is item 70. My lord, case diary is with the item 70, my lord.
It's all right, but just give a copy. Copy has not been given. How can he verify what is the case number? State Council को सोमवार दिन कॉपी टे दे दियंतु.
ଆଜ୍ଞା madam. ଆଜ୍ଞା madam. Sir, 70 ରେ tag ହେଇଗଲା.
Tied up कर दबा कହୁଛନ୍ତି ତ?
ଆଜ୍ଞା.
Okay, Mr. Mahapatra further submits that this matter is connected to item number 79 means 70. Some other council, I cannot adjourn without.
Mine for 17.
79. 79 to?
70.
Oh, 70. 70. Okay, 70. That is BLAPL number 512023. Okay. Yes. Matter to be listed with so item number 15 टा ता संगे list हो.
15 टा.
Okay. With item number 15. 15 ने लिख देबो with item number 70. Yes.
Copy also served.
So 70 रे भी copy देना.
17, I have solved already. 17. 17.
Oh, sorry. 70 for
Okay.
70 रे भी लिख दियंतु copy solve. Yes, next.
May I please, your honor. Item 6. Offense under.
Item 16.
May I please.
Press matter, you have received the case diary?
Yet to receive, my lords.
Okay.
Case diary is available in PLAPL number 10583 of 23. 1067023.
Achhi na dispose of case law.
Pending.
Dekhi
And one of the accused stands on similar footing.
Next week anuchi dekhi verify.
Lordship, I am supplying the order mail. Whether they stand.
The London Council for the state submits that he has not received the case diary. Land Council for the petitioner, on the other hand, submitted that the case diary may be available in connected case records. He has furnished the case numbers to the Land Council for the state. Let the Land Council for the state verify the same. Land Council for the petitioner further submit that co-accused persons have been released on bail.
Another accused. Another order is there.
Okay, co-accused persons have been released on bail, and he handed over the copy of the bail order to the Land Council for the state. Let the Land Council for the state also examine the claim of parity put of this matter on such and such date. Yes, next.
Item 17.
May I present? Offense under 21 and 29 of NDPS
Please
Act.
use the mic properly.
Offense under 21 and 29 of NDPS Act. Earlier application was rejected, and another application, Your Honor, has been granted an interim bail for a period of 3 months.
केबे लास्ट ଦେଇଥିଲି
21/7
21/7/2023 ठीक समय सरेंडर कले वर्तमान पोजीशन कोन
Position matter only 3 witnesses have been examined out of 27.
27 the status report also देखिए लेकिन the London Council for the petitioner submitted that earlier the petitioner was granted interim bail for a period of 3 months in BLAPL number 6577 of 2022 as per order dated 21/7/2023, and after availing the same he surrendered at right time, and he has received instruction that only 3 witnesses have been examined
Out of 27.
27 charge sheet witness. Let a status report be called for, matter be placed on such and such date. While submitting the status report, the London trial court shall indicate as to whether after availing the interim bail period, the petitioner surrendered at right time or not. CDCA be obtained in the meantime. Yes.
Item 18.
Please.
Mr. Sahu, Bikram Keshav. Yes.
Sorry, senior counsel.
I was on BC.
Yes, sir. You will argue the case. Okay.
Yes.
Yes, sir.
May I please, Your Lordship? In this case, my lord, charge was framed on section 302, reduced section 120B of the Indian Penal Code.
You have received the case records?
Oh, yet to receive. Fresh matter.
Okay.
Also, 34 witnesses have been examined out of 51, as per the trial court order.
51 to 34.
34, my lords.
And what is the trial court order dated?
Order date is 17/10/2023, Your Lordship.
That is the position, or any further witness, Mr. Mahapatra, has been examined?
No, almost all the witnesses. Your Lordship may have a glance to the order I am placing.
One of the co-accusers.
One of the co-accused. Your Lordship has taken note of everything. Dilip Kumar Sharma.
Let him obtain so that it will be disposed of.
In that case, Your Lordship will discuss everything.
And Mr. Saurachandra Mahapatra and senior advocate for the petitioners also, Mr. Bikram Kesari Sahu, Land Council, appearing through virtual High Court Raurkela. The London Council for the state submit that he has not received the case diary, and he has, and as per the rejection order dated 17/10/2023, out of 51 charge sheet witnesses, 34 witnesses have been examined so far. When a query was made to the London Council for the petitioner as to whether any further witnesses have been examined thereafter, he ensured that no further witness has been examined. Let a status report be called for from the London Trial Court, and while submitting the status report, the London Trial Court shall specifically indicate as to how many witnesses have been examined and how many witnesses have been declined by the prosecution and
that was reflected, my lord, in the earlier order.
earlier order.
Yeah.
All right.
ସବୁ ଯାକ ତାର ମେନସନ ହେଇଛି କେତେ ହେଇଛି ଡିକ୍ଲାଇନ କେତେ ହେଇଛନ୍ତି 16 ଜଣ ସାକ୍ଷୀ ଡିକ୍ଲାଇନ ହେଇଛନ୍ତି.
Okay. The put of this matter on such answers.
I am suggesting one thing, my lord.
Yes.
Case diary is available in BLPL 34838 of 23.
देखी दियो
अब दे देइछि से देखि देले सेटाको
Plan and counsel for the Mr. Mahapatra submit that the case diary may be available in BLAPL number so and so. hala nahi khali lagi do in a connected case record and the number of the application has been supplied to the land and council for the state to seek some time to verify the same. Yes,
next week रे आसीगले.
Item 19.
May I please, my lord, I'm through virtual mode. My lord, the petitioner is in JC since 10/2/2022. And my lord, while rejecting the first bail application of the petitioner, my lord has this honorable court has directed the London Trial Court to conclude the trial within 6 months from the date of the order, that is 3/7/2023. But my lord, as per the instruction, out of 16 witnesses, only 2 witnesses has been examined yet.
All right. Let me obtain that status report. This Kiron Pandey, Land Council, appearing through virtual mode, submits that when the petitioner earlier approached this court in BLAPL number 5891 of 2022, the same was disposed of as per order dated 3/7/23. And while rejecting the bail application, Land and Trial Court was directed to expedite the trial and conclude the same within a period of 6 months from the date of framing of the charge. And the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. When the charge was framed, madam?
My lord, the charge was framed in
because the submission which you made that it is from the date of order 6 months, that is not correct because the order reads that it is to be 6 months is to be from the date of framing of the charge.
my lord, in page number 19 of the said order, I am may I read, my lord? I am directing the London Trial Court to expedite the trial and conclude the same within a period of 6 months from the date of the framing of the charge.
It's not from the date of order, that is what I am pointing out. So that is why I am asking you that when the charge was framed. You are not aware about it. All right.
No.
While submitting the report, the London Trial Court shall specifically mention about the date of framing of the charge. Yes, next.
My lord, it is a humble submission. My lord, as the petitioner is a resident of Uttar Pradesh, so my lord, liberty may be granted to supply the surety documents and verification document of the address.
First the document status report come, then we'll see that they khali lekhi diyondu. Since the petitioner is a man from Uttar Pradesh, Raebareli, Uttar Pradesh, the Land Council for the state shall verify through so and so whether the address furnished by the petitioner in the cause title is the correct one or not. Yes, free copy of the order be handed over to the Land and Council for the state. Yes.
Obliged, my lord.
Item 20.
20, may I please, your lordship, is a case of 302/34 of IPC. Out of 15 accused persons, 14 have been released on bail.
Fresh
matter. Fresh matter, my lord. Your lordship.
Let it come that the Land and Council for the state seeks some time to produce the case diary and
last
criminal antecedent.
My lord,
Land
the last
Council for
BLAPL was, sorry,
submits that some of the co-accused
13718.
persons have been released on bail.
13718 of 2020.
Let the bail order copy be supplied to the Land and Council for the state. Will verify regarding the claim of parity. Put up this matter on such and such date. Yes, next.
Item number 21.
Lord, I will file a represent copy prefer next week.
You will file or you have filed?
I will file.
Will file. The Land and Counsel for the state submit that he has not received the case diary. And counsel for the petitioner submit that he has instruction that some of the witnesses have been examined in the trial court, and will file the certified copy of the deposition for the court and supply set of deposition for the to the Land and Counsel for the state. List this matter on such and such date. Yes.
Item number 22.
May I please, your lordship?
Yeah.
Earlier occasion, the petition moved before the honorable court, and my lord rejected the bail application.
Instruction.
In fact, so far the implication of the petitioner is concerned. In fact,
petitioner is a local newspaper correspondent. At his instance, a PIL was filed before this honorable court.
Just a minute. You are granted interim protection and with a further direction that you are to cooperate with investigation.
Yes, sir.
Did you comply the order? Have you cooperated with investigation? Yes, Mr.
I will take
What is your
instruction.
instruction?
Well, I'll take instruction. Lordship, the last order, now order sheet is on 17/5/2022, Your Lordship.
Right, 17, no, it is 19/5/2020. 19/5, the order reads like this, that after going through this so and so, the petitioner is directed to appear before the IO on such and such date. The date was fixed.
Lordship.
And to cooperate with investigation, further appear before the IO as and when required. And then he was granted interim protection. Thereafter, this matter has not been listed.
Lordship.
So I just want to know whether at any point of time you required his assistance or appearance and whether he cooperated or not. So
Lordship.
that much of instruction. The as per order dated 19/5/2022, the petitioner was granted interim protection. However, he was directed to appear before the IO on a particular date and to cooperate with investigation and to further appear before the IO as and when required. And the Land Council for the state was also asked to obtain instruction whether the petitioner appeared before the IO on the date fixed and whether he cooperated with investigation or not, and also to obtain instruction about the result of such interrogation by the next date. Land Council for the state submits that he may be given some time to obtain instruction as per order dated 19/5/2022. Put up this matter on such and such date. गोटे सप्ताह पर शुक्रवार रख देवे. Interim order dated 19/5/2022 is extended till next date. Free copy of the order be handed over to the Land Council for the state along with the order dated 19/5/2022. 19/5 ରେ ଅଛି ନା ଦେବି?
Lords, order, I'll get the order, Lords. I'll download it.
Is it been uploaded? We do not know. That's why I'm asked to supply a copy to you.
Lordship may be kind enough to, my Lords.
Item number 25.
Yes,
I'm appearing for the informant, my lord. Mr. Jagannath Patnaik, senior advocate, was arguing.
Not given to you. All right, I'm passing it over. Please send a message to the Land Senior Advocate team.
I'll call him.
Item 26.
My place, my lord.
issued against the petitioner or not.
80 to 83.
Yes, my lord.
Kebega case claim.
Case is the 2019, my lord. 2012, my lord.
12, no?
Yes.
Also, my colleague next week I'll get the instruction.
Land Council for the state seeks some further time to obtain instruction in compliance of the order dated 5/10/2023. Put up this matter on Ajiyallah 5 तारीख ना 5 पहले 12 तारीख तक 12th January 2024. Yes.
No, next item also same instruction was sought for.
Anichandji.
No, Your Lordship, I'll get it next week.
Oh, same order.
In both the cases, interim order to continue.
Interim order थी लगी?
Yeah.
अच्छा, interim order to continue till next day. Yeah.
Item 29.
May I please, Lord? My lord, order
82, 83 process. Instruction I have not yet received.
Get it next week, madam. The land council for the state submits that he is yet to obtain instruction in consonance with the order dated 1/2/2023 regarding issuance of processes under section 82 and 83 CRPC could of this matter on 12/1/2024. Yes.
Item 32.
May I please? On the basis of the FIR lodged by one Rohit Naik, initially FIR was registered against one Sanjeev Pradhan, advocate, and Vijay Kumar Pradhan, advocate, and Pradeep Kumar Dhala, another advocate, and one Prasanna Kumar Naik. The father's name of the petitioner was not given. Accordingly, the FIR was registered in the year of 2017 in an offence under 419, 420, 467, 468, 34 of the Indian Penal Code. During the course of investigation, the IO of the case has spread before the learned magistrate on 12/9/2023 to inserting the name of the present petitioner as well as the father's name of the present petitioner. It is alleged in the FIR that the informants are the displaced persons and they have filed.
Who has been granted anticipatory bail?
The advocate Pradeep Kumar Dhala. The petitioner is a 80 years old person and was also a retired employee having no criminal antecedent.
Pradeep Kumar Dhal, advocate, is also a notary public.
Madam.
So he has been granted. Now your name finds place as accused number 4.
But my father's name was not given. In the same person, same name, there are 3 persons available in that locality. But on 12/9/2023, the IO has made a prayer before the magistrate to issue NFW against the present petitioner. After coming to know about the same, the petitioner filed this bail application.
It's all right. There must be some basis that it is you, even though in the FIR the father's name has not been reflected, but during course of investigation,
nobody has stated that I am the
first time
some protection is required. 80 years old person, for that
allegation
I have taken the money. The advocates who are arrested by the IO, they have never stated that I was withdrawn the money.
ওই যে রেঙ্গালি ড্যাম প্রজেক্টর ডিসপ্লেস পরসন কো টଙ୍କା
My lord,
ତାକୁ କଣ ଆପଣ ନେଇଗଲେ କେମିତି?
I have never taken. But
ଗରିବ ଲୋକଙ୍କର ପଇସା ତାକୁ
my lord, your lordship may kindly see the order dated 12/9/2023. Till that date, I was never added as an accused.
ସେ ଲୋକ ନାଁରେ ଆପଣଙ୍କ ନାଁ ସମାନ ହେଇଛି, ତା ଜମି ଯାଇଛି।
My lord, my father's name is also same. I have never filed any land acquisition case before the authority or before the court. I have never gone to the court at any point of time. But when on 12/9/2023, the IO has made a prayer and searched me, I filed this petition. I am ready to cooperate with the investigation, my lord.
Ready କଣ ପଇସାଟା ନେଇଛନ୍ତି ଫେରେଇବା ready କଣ?
My lord, I have never taken a single pie.
ଆରେ ଦସ୍ତଖତ କରି ନେଇଛନ୍ତି ଆପଣ କି ଆଚ୍ଛା ଏକ୍ସ ନାଁରେ ହେଇଛି, ଆପଣଙ୍କ ନାଁ ଏକ୍ସ ସାଙ୍ଗରେ ଟାଲି କରୁଛି, ଦସ୍ତଖତ ମାଇଲେ ତାଠୁ ଚେକ୍ ନେଇ ପଳେଇ ଏନକ୍ୟାଶ କରିଦେଲେ ଆଉ କଣ?
Even if the other 2 advocates who were apprehended, they have never stated that I was the person in their presence I was taken the money.
ଆଣନ୍ତୁ କେସ୍ ଡାଏରୀ।
My lord, interim protection, 80 years old person, my lord. 80 years old person.
Take instruction whether you are ready and willing to refund that money or not. Land and Council for the state takes some time to obtain the case diary. Land Council for the petitioner submit that the petitioner is 79 years old and he may be a person, he may be granted interim protection till the next date. Let the Land Council for the petitioner obtain instruction whether the petitioner is ready and willing to refund the misappropriated amount or not. put up this matter on such and such date, interim protection granted. Yes. Let it come next week, man. I will obtain the CD. I have already talked with the IAC. Interim protection ना देंगे. Let it be taken up next week, man. आसु. बुढ़ाटा नहीं कौन करेगा? Yes. Interim protection given, man. Yes, sir. Till 12th year.
Item number 33.
May I please your lordship? It is a Banki double murder case. The lordship granted all the accused persons with regime order. Initially, while lordship granted bail, observe that Pappu Pradhan and the Balabhadra Paliya Pradhan is the accused, and they are also in the meantime granted bail. And the lordship elaborately discuss regarding Pappu Pradhan and Balabhadra Pradhan also.
Verify करिए.
ये last लोग रही report hero है.
Copy टे दिया. Pitson copy नहीं. Pitson
ଆଜ୍ଞା ଆଗରୁ adjourn ହେଇକି ଅଛି ଆଜ୍ଞା.
ଆରେ Pitson copy ତାଙ୍କ ପାଖରେ ନାହିଁ. Verify କେମିତି କରିବେ ସିଏ? Pitson copy ଦିଅନ୍ତୁ. Order ଗୁଡାକ ଦିଅନ୍ତୁ. Verify next week ଆସିବ. The learned counsel for the petitioner handed over the copy of the देले तो copy. Handed over the copy of the bail application. So also the
अभी दे देंगे course of the day.
Acha. Submit that he will supply the copy of the bail application to the land council for the state during course of the day, along with the bail orders of the co-accused person.
My lord, all the other co-accused persons granted bail. My
council for the state shall verify the claim of parity. Put up this matter on 12/1/2024. Yes.
So already 5-6 adjournment has been.
How time दिया हुआ?
Case of 2020.
Yes. Next.
Item 34.
It become infructuous, my lord.
And counsel for the petition submit that the matter has become infructuous, disposed of as infructuous. Yes. Next.
Item 35.
1 week after, my lord. Mr. Saul and counsel for the petitioner praised for an adjournment. You have received the case diary? If I, my lord, and counsel for the state submit that he has received the case diary. This of the for appropriate. Yes.
Item 36.
May I please yourself. This case, your lordship, last time that call for the status report of this case. Asila. ଷୋଳଟା ସାକ୍ଷୀ ଆଉ ଅଛନ୍ତି ଏକ୍ସାମିନ୍ ହବାକୁ ଟୋଟାଲ 16ଟା ସାକ୍ଷୀ 16 ରୁ 4 ହିସାବ ଏକ୍ସାମ୍ କେବେଠୁ ରହିଲେଣି 24/9/2021 ଲୋକ କୋଉଠିକା ମାଲକାନଗିରି ଓଡ଼ିଶା 24/9/21 ଆଜ୍ଞା 2 ବର୍ଷ 3 ମାସ ଆଉ ଯାଇନାହାନ୍ତି ଇଣ୍ଟରିମ୍ ବେଲରେ You see that the co-accused Mukesh Kumar on 17/1/2023 that the order has passed expeditiously within 6 months. That, yes, Mr. Tripathi. That second item, my Mukesh Kumar is from UP. No, we are concerned first item. First item is a local man. Local. Are the land and counsel for the petition, land counsel for the state, land counsel for the petitioner submit that the petitioner is in judicial custody since 24/9/2021. And the trial is still continuing and the prosecution evidence is not yet closed. Status report submitted by the land trial court indicates dated like the 12/12/2023 indicates out of 16 charge sheet witnesses, 6 more witnesses are to be examined. Sit like the and that and he is a local man, there is no chance of absconding and he may be granted interim bail for some time on account of delayed disposal of the trial. Land counsel for the state oppose the prayer for bail, considering the submission in view of the commercial quantity of ganja and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail, but taking into account the period of detention in judicial custody and the slow progress of the trial and the fact that the petitioner is a local man, I am inclined to release the petitioner on interim bail for a period of 3 months, disposed of. Yes. এটা লিখে দিও Mr. Nihar Ranjan Sahu is there?
Yes, sir.
Yes. That what is this man as an outsider, the address verification has been made.
No, no, you'll see. No, I'm not questioning that.
Korea loco.
UP errors.
Okay, you obtain instruction about that. The Learning Council for the state submit that the petitioner is a man from state of Uttar Pradesh, and he may be given some time to obtain instruction whether the address furnished by the petitioner in the cost title is a correct one or not. बाकी usual order कर देगी ना, दे देगा। गोटे सप्ताह पर पकेगा। Yes,
Pleasures.
Item number 37.
Lord, item 37 offense under NDPS Act, your lordship, direct target the trial में।
हाँ कौन करती
Trial में kindly be target.
Okay, केबुट रोइलेनी।
Since 23/8/2021.
23/8
21
2021 आरंभ ହେଲା ନା ଜମା ହେଇନି?
ଆଜ୍ଞା ଆରମ୍ଭ ହେଲା।
Are the Land and Council for the petitioners, Land Council for the state. The Land Council for the petitioners submit that the petitioners are in judicial custody since 23/8/2021. And since there is slow progress of the trial, the Land and Trial Court may be directed to expedite the trial and conclude the same within a particular time limit. And Council for the state has no objection, considering the submission while not intending to release the petitioners on bail, taking into account their period of detention. I direct the Land and Trial Court to expedite the trial and conclude the same within a period of 6 months from the date of receipt of the order. Yes, next.
Item 38.
Statement on behalf of Mr. A.R. Ponda, my lord. Refer next to it.
Mention is made on behalf of Mr. Panda to the Republic of India, Mr. There. To adjourn the matter, the Mr. Sarthak Naik ko na likh duchi.
Yes, sir.
Mr. the Land and Special Public Prosecutor for CBI is present. Yes, he is adjourned. Yes.
Item 39.
May I please, my lord? My lord, offense number 20/2C 27 and 29 of NDPS Act, my lord. And last occasion, my lord, honorable court directed to take instruction regarding the stage of trial, my lord.
Report as out of 16 charge sheet witnesses, 8 witnesses have been examined. 3 have been declined. 8 3 11 गले और रहला 5. Okay, केबुट रोइलेंड
Custody since 14/9/2020, my lord.
14 no कोडे जाइना दी इंटरिम
No,
बेल
no, my lord.
कोटिया लोग को
UP, my lord.
UP
My lord.
address verification नहीं ची
No.
कर दें address verification कर दें man of Agra Uttar Pradesh address verification let it come and so on. So yes.
Pardon your lordship. Lordship, in this matter, the co-accused matter was to be tagged up, and he is also a man from UP.
Okay, list this matter along with Kund number Kund
8027
BLAPL number
of 2020.
8027
Yes, sir, lordship.
of 2022.
Lordship, and he is also a man from UP.
It is stated at the bar that the petitioner na Kund Dutadhir
Kuldeep Rawat alias Kumar alias
Kuldeep Rawat.
Yes, sir, lordship.
Good kagajar likhi diyon.
Yes, sir.
Who is the petitioner in this case is also a man from Uttar Pradesh. The Land and Council for the state will also verify the correctness of the address furnished in the post rate of BLAPL number 8027 of 2022. Free copy of the order be handed over to the Land. Yes.
Item number 40.
Lordship, in item 40, the petitioners are in custody for commission of offence punishable under section 376DA 294
My lord, out of charge sheeted witnesses, 24 and 9 witnesses are examined and another which was a religion bail. Earlier, my lord, let's direct to the examine the informant. PW 5 and 6 is the son and sister. They have stated the informant died. In year of 29,
Is it
21.
past application or earlier rejected?
Well, it is earlier reject, earlier withdraw. Then 1 and 2, I have given certificate. That's the first application.
Okay.
So, death certificate and another COACU certificate. Order also I'm supplying my lord. The COACU of the religion bill, my lord.
Now the trial has commenced.
Already 9 witnesses are examined.
Have you supplied the deposition copy?
Yes, my lord. File, my lord. Page number 26 and so let's see, come to page number 24, 25. Sorry. 26, 27.
Wait,
The son and
just have patience. Why are you so impatient? You are making a submission. I am verifying it. You go on continue your submission. How can I verify? Yes, so 8 witnesses have been examined and they have not stated anything against you, right? So, Mr. Tripathi?
Yes, sir.
But the PW8, as it appears, he was examined on 3rd September 2022. So we are in 2024. Do you mean to say that within this span of 1 year and 3 months, no further witness has been examined?
I have obtained the certificate of the same 28/11 till no witness are examined. ତାପରେ ବି certificate ମାଗିଲି।
8ଟା ପରେ ଆଉ କେହି ନା?
ନା 28/11 ଅଛି। Let's be kindly glance.
Just a minute. 9 number ସାକ୍ଷୀ ହେଇଛନ୍ତି। ଆଚ୍ଛା ସେଟା ହଉଛି ଲକ୍ଷ୍ମଣ ଚକ୍ରବର୍ତ୍ତୀ। ଏଟା ହଉଛି 7th February 2023 ରେ। No, you are not producing the order sheet. You are producing the deposition copy of 9 witnesses, which indicates that the last witness, that means PW9, was examined on 7th February 2023. So simultaneously, you should have produced the order sheet from that day onwards to show that no further witness has been examined.
Till 28 November, no other witnesses are examined. Further, I have.
All right, let us get the instruction about that. You have obtained the case diary?
My lord. And I was verifying the case diary also, my lord. 2 more eyewitnesses are still there.
No, it's all right, but if you do not bring them to court and you are producing as many as 9 witnesses by February 2023, if there are eyewitnesses, material witnesses, they should have been examined at the first instance. Why are you withdrawing them? And so let us see that first deposition. Who are those eyewitnesses, you say? Mr. Tripathi?
My lord.
Eyewitness na kon kon?
ଗୋଟେ ହେଲା ଦେବେ ମାଢି
ଯେ
DEBEMADHI
ବେବେ
ଦେବେ
BA na
D for Delhi ଦେବେ ମାଢି
DEBE
she is the daughter of the deceased
ହଁ ଦେବେ ମାଢି ତାପରେ
ଆଉ ଗୋଟେ ହେଲା
ଗୋଟେ କାଗଜରେ ଲେଖି ଦେଇଦିଅନ୍ତୁ ଦି ଜଣ Learned counsel for the petitioner produce the certified copy of the first information report along with the certified copy of deposition of 9 witnesses, from which it appears that PW9 was examined. PW9 the na likhi diyantu. Lakshman Chakraborty was examined on 7th February 2023. Learned counsel for the petitioner submits an instruction that after PW9, no further witness has been examined in the trial court. However, since he is not producing the certified copy of the order sheet from 7th February 2023 onwards, let a status report be called for from the London trial court. If any further witness has been examined after PW9, the London trial court, while submitting the status report, shall send the Xerox copy of the same to this court so as to raise this court on or before so and so put up this matter on such and such date. Learned counsel for the state, on the other hand, submits that so and so are the eyewitnesses to the occurrence and they are yet to be examined. The London trial court shall indicate whether any summons have been issued to the aforesaid eyewitnesses or not. Hala? Yes.
My last occasion, Lordship direct to examine the informant.
We'll see that on the next day. Yes, next.
Item number 42.
Mr. Nando, Prashant Kumar Nando. He's not there. Paso. CD available? Yes, sir. Okay, Paso.
Item 43.
43, Mr. Naik.
May I please? The last
And
occasion,
another
Milord.
matter is there, Mr. Pandai.
Yes, I am there, my lord.
Yes. CD
Yes.
available? Yes, sir. Okay.
Milord, out of 59 charge sheeted witnesses, Milord,
Yeah.
31 have been examined in the meantime.
Is it the first application or earlier?
No, this is the my application, Milord. My case is the second application, Milord.
Earlier application number is?
Earlier application number is, Milord, BLAPL number 5821 of 2021.
Just a minute. କୁହନ୍ତୁ ଆଗ ନମ୍ବରଟା କୁହନ୍ତୁ
5821 of 2021, my lord, disposed upon 14/2/2022.
କପି ଅଛି ଅର୍ଡର କପି
Yes.
କଣ ପାଇଁ ରିଜେକ୍ଟ ହେଇଥିଲା କଣ
That order copy is not available. My lord, Justice A.K. Mahapatra, my lord, disposed of that.
No, I just want to see that why it was rejected, the reason for rejection. That's it. Is that,
It was at the early stage, my lord.
Mr. Naik,
My lord.
uploaded in the High Court.
Uploaded.
Hey, Bharko. BLAPL number.
Uh, 5821.
5821 2021. That was not uploaded. Naik. It was disposed of by Justice A.K. Mahapatra. The only order that is uploaded is dated 10/8/2021. Okay, now what is the position you said just?
My lord, I took 51 charge sheeted witnesses, my lord, 59 charge sheeted witnesses, my lord. 31 numbers of witnesses have been examined, my lord. And the informant in this case has died, my lord. He is not deposed. He is the son of.
What these witnesses have stated against you?
My lord, against it, it's omnibus, my lord, because there is no eyewitness to the occurrence. All of them are post-witness occurrences, post-occurrences witnesses.
What is the date of custody of this petitioner?
Date of custody, my lord, 2nd of January 2021, the date of incident, my lord. And custody since 22nd of January 2021.
22/1/2021,
my lord.
Charge sheet submitted under section?
Charge sheet submitted under section 120B, 302, 341.
Just go slowly.
My lord.
341.
109, my lord. And 34 of IPC. Read is section 25 and 27 of the Arms Act.
Name of the deceased?
Name of the GC is, my lord, my lord, Kulamani Parada. And my lord, another is my lord, Nursinga. My lord,
The second one is Dibya Singh Avara.
Dibya Singh Parada.
Okay. Have you supplied the deposition copy to the State Council?
Lords, out of 31, I have received only up to 26, Your Lordship.
No, I believe all copies were supplied. Your Lordship directed on 8/12 for the.
ତିନିଟା କପି ଆମେ ଦିଆ ହେଇନଥିଲା ଆଜ୍ଞା ମୁଁ ସେଟା ଦେଇଦେବି ଆଜ୍ଞା ମୁଁ I have given the bunch
26 I have, my lords. PW
rest my lord.
ଆଉ
The last occasion my lord.
ବାକି ରହିଲା ଆଉ 5ଟା ରହିଲା ନା?
ହଁ 5ଟା.
So ଦେଖନ୍ତୁ the Learned Counsel for the petitioner submitted that out of 59 charge sheet witnesses, 31 witnesses have been examined in the trial court. The Learned Counsel for the state submits that he has received the deposition
28, my lords.
deposition copies of 28 witnesses. The Learned Counsel for the petitioner submits that he will supply the deposition copies of the rest 3 witnesses to the Learned Counsel for the state by Monday put up this matter on 12/1/2024.
Lords, can I submit?
Yes, Mr. Panda.
In the connected matter where I am appearing,
yes,
Your Lordship passed an order on 8/12, 8/12/2022.
8/12
By then, 29 witnesses had been examined.
ବର୍ତ୍ତମାନ ତ 31 ହେଲା।
ଆଜ୍ଞା। By now, 32 witnesses have been examined. That is my instruction. 11 have been declined.
31 ପର୍ଯ୍ୟନ୍ତ ମୋ ପାଖରେ ଅଛି ଆଜ୍ଞା deposition.
ହଁ ଯଦି ହେଇଥିବ ଆଉ ଦେଇଦେବେ
ମୁଁ
32ଟାକୁ ଦେଇଦେବେ। ଡିକ୍ଲାଇନ୍ ହେଇଛି କେତେ ମିଷ୍ଟର ପଣ୍ଡା କହୁଛନ୍ତି?
11 witnesses.
ଆଚ୍ଛା
That is also apparent from the report which your lordship called for from the.
Acha, Mr. And 11 witnesses have been declined.
Yes.
To examine this, what evidence has come against this 2 petitioner. प्रत्येक केस रे जणे जणे पिटिशनर अछन तो मलय बारिक सिंगल आउ से जो ललित मोहन बराल भी सिंगल ऑलराइट along with it as your 12 तारीख दिन yes.
Item 44.
To obtain CD and antecedent.
Finally,
yes, sir. CD is available.
Our going to
CA is also available. Yeah, 12 CA, man. 12 criminal antecedent.
File the comprehensive affidavit.
I will file today.
The Learned Counsel for the state submit that he has received the case diary.
I have affidavit, man. If
you are having that affidavit. So file it and give a copy to the state council. Learned Counsel for the state submits that the petitioner has got 12 criminal antecedents.
Yes, sir.
Learned Counsel for the petitioner files the copy of the comprehensive affidavit in court, giving copy to the Learned Counsel for the state who wants time to verify the same, put up this matter on such and such date. Yes, next.
Please.
Item 46.
May I please, your lordship? My lord, the last occasion.
You use the mic.
My lords. May I permit it to my lords?
Yeah.
Lord, the order dated 8/12,
Diary
2023.
Yes, diary. Okay.
Yes, diary. Yes, diary.
Yes, certainly.
8/12, 2023, my lords, last order. That's the
8/12/23.
my lords, 8/12, 2023.
Submit that written instruction received from so and so to the effect that documents of two local sureties are found genuine, expressed willingness to start. Okay. Said document has been made to this so and so to address verification ପାଇଁ ଥିଲା Mr.
Yes, Lord.
ହେଲା କଣ ହେଲା?
Yes, the address given by the petitioner is correct.
କପିଟି ଦିଅନ୍ତୁ। କେବେଠୁ ରହିଲେଣି?
That's the 14/11/2019.
ତା ଭିତରେ ଯାଇନାହାନ୍ତି ଆଉ interim bail ରେ?
No, my lords, no.
Status report କଣ ଆସିଲା?
Plus I have supplied the file plus the deposition copy on 21/7/2023. Only plus the out of 12 that plus the 5 only examined plus till date.
Total number କେତେ?
12 plus 12 charge sheet witnesses.
Okay. 14/11/2019 ठीक था मिस्टर?
Yes. Yes.
चार्ज शीट हाँ कॉपी चार्ज शीट कॉपी
Charge sheet copy with me, my lords. My lords. Yes.
नहीं ठीक अच्छी तो?
Yes.
All right. Are the land and council for the petitioner land council for the state? The land and council for the petitioner submit that the petitioner is in judicial custody since 14/11/2019. And out of 12 charge sheet witnesses, only 5 witnesses have been examined in the trial court. And since the case is lingering without any fault of the petitioner may be granted interim bail for some time. Land counsel for the state had already obtained instruction about the genuineness of the two local sureties, so also the authenticity of the documents of the two local sureties whose names were furnished by the land council for the petitioner, and the same is reflected in the order dated 8/12/2023. Today, the land council for the state has produced written instruction received from such and such that the address verification has been made, and it is found that the address furnished by the petitioner in the cause title is correct. The report is taken on record. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody and the slow progress of the trial, while not inclining to release the petitioner on bail on merit in view of the commercial quantity of ganja seized and bar under section 37 of the NDPSR, I'm inclined to release him on interim bail for a period of 3 months. And the two local sureties would be Mr. Tripathi?
Yes.
The dita local surety on na kundu.
Yes, sir.
ଯାହାକୁ ଭେରିଫାଇ କଲେ ମୁଁ ଆପଣ ଆଣିଲେ ପୁରା
ଭେରିଫାଇ ଆଡ୍ରେସ ଭେରିଫିକେସନ ହେଇଛି ଲୋକାଲ ସିରୁଟରେ
ହେଇଛି ଆପଣ କହିଲେ ସବମିଶନ
ମୁଁ ଆଣିନି ମୋ ପାଖରେ ନାହିଁ
order sheet which were reflected
this order 8/12/2023 ଆପଣଙ୍କ ସବମିଶନ ଥିଲା ଯେ you have received the written instruction dated 16/10/2023 from the inspector in charge of Patangi police station to the effect that the documents of two local sureties are genuine. They expressed willingness to stand. ଲେଖା ହେଇଛି ପୁରା ସବୁ
ସତନ ମୁଦୁଲି and
ଆପଣଙ୍କର ଚିଠି ଗୋଟେ ଥିବ ଦେଖନ୍ତୁ 16/10/2023 ର जोटा कि पटांगी थानार आईआईसी आपनको लेखिकिन देइथिले से डॉक्यूमेंट्स ता पूर्वरु आपनको सप्लाई हेतला वेरीफाई करना दिको
Yes, sir.
अछि तो
हाँ,
ओके ओके
सदना मुदुली
कोन नाटा कोन
सदना मुदुली
सदना
yes
SADANA
yes
मुदुली आउडे की
भक्त हरिजन
भक्त हरिजन लिखिए दीटा ना दे विल बी दिस लोकल sureties for the petitioner है ना all right next
Great, Paul.
Item 47.
Please, Lordship. The petitioner surrender on dated 2nd January 2024. Surrender certificate 1 week time may be given.
The land counsel for the petitioner submitted that he has instruction that the petitioner has already surrendered before the land and trial court on 2nd January 2024 and he may be given some time to produce the surrender certificate. Next week,
Next week.
Court of this matter on 12/1/2024. Land
Okay.
counsel for the petitioner shall produce the surrender certificate. Yes, next.
Public.
Item 48.
May I please, my lord, through virtual mode. My lord, I'm appearing on behalf of Mr. Manohar. My lord, on last date of hearing, my lord has directed the state council for to submit the surety verification report.
Last order means is it 19/10/23 or thereafter any order was known?
My lord, on 2012, the state council has taken some time.
Time
for-
okay, for address verification. Hela ki address. Who de loko?
yes that I have taken instruction
Yeah.
that Muddi Harijan he died Muddi
ये petitioner name is Sumit Hari Saran.
Yes, my lord.
address verification
Address verification.
address verification
Are you holding that BLAPL number 1185 of 23?
yes my lord 1
Okay, there was a direction to make address verification. So whether it has been done or not, and if so, then what instruction you have received?
yes my lord that is correct.
Correct.
Yes.
And has she furnished the two local sureties to you?
Two local surety. One is that since 2 years.
Miss Pandey,
Yes, my lord.
two local sureties you furnished, one of them is dead since 2 years. So how a dead man will take you as the petitioner as surety?
My lord, as per the instruction that we have we have supplied the valid sureties.
I'm writing out you are to furnish another local surety, mentioning who is dead out of the two. Pathile.
No, what?
The London Council for the State on instruction received from so and so. Say you address verification kartile. That the address furnished by the petitioner in the cause title is correct. However, he submits that out of the two local sureties whose names and documents were furnished by the London Council for the petitioner, one of them, namely so-and-so, is found dead since 2 years. And counsel for the petitioner submit that he will file the, he will submit the name of a fresh surety with his documents to the land council for the state within such and such date, on receipt of which instructions shall be obtained regarding the genuineness of the bailer, so also the authenticity of the documents put of this matter on such and such date. Do you want to say data which it is? Yes.
Obliged, my lord.
Please, your lordship.
ନା ଲେଖିଦେଲେ କ୍ଲିୟର କରୁଥିଲେ ଭର୍ଚୁଆଲ ମୋଡରେ
Item
Yes.
49.
May it please the Lordship. Lordship, on the last occasion, instruction was called for regarding the health of the petitioner, Lordship.
Interim bail application you have given?
Yes, Sir, Lordship.
It is on account of the health condition
Yes,
of
sir,
the
Lord.
petitioner.
Of the petitioner.
Yes, what is the instruction? Would look would you
Outside the Lordship.
address verification ହେଇଛି?
No, Your Lordship.
କରିଦିଅନ୍ତୁ ଆଉ local surety ଦିଟା ଦେଇ ଦିଅନ୍ତୁ।
Yes, Your Lordship.
The land council for the IN number 1 is an application for interim bail on the ground of ailment of the petitioner. The land council for the state has obtained written instruction regarding the health condition. The same is submitted, which is taken on record. And counsel for the state, however, submit that the petitioner is a man from Jodhpur, Rajasthan, and he may be given some time to make necessary address verification to so and so. Let the land council for the petitioner furnish the names, documents of two local sureties who are interested to take the petitioner on bail to the land council for the state by next week or those.
Yes, Your Lordship.
On receipt of which same shall be verified and matter be listed on such and such date. Free copy of the order be handed over to the
Lordship, at presently the petitioner is in Chaudhar jail, Lordship, because another surgery has to take place.
Reporter କିଛି problem ନାହିଁ ଖାଲି ଦରକାର address verification.
Yes, Your Lordship.
Yes.
Oh, bless you.
Item 50.
Yeah, please, Your Lordship. Petitioner inside the custody since 20th September 2022.
First time ଆସିଛନ୍ତି ନା ଆଗରୁ ଆସିଥିଲେ?
This is first time.
Case diary ଅଛି?
Yes, ma'am. Yes, ma'am.
What is date of custody?
20th September 2022.
20th September
22, my lord. These are
22. Offense under which charge sheet submitted?
302-201-34 IPC.
Name of the deceased?
Name of the deceased one go. জগবন্ধু মাঝি। জগবন্ধু মাঝি।
Eyewitness ଅଛନ୍ତି?
Several eyewitness.
ଜଣ ନାଁ କହିଲେ?
Both PW1 is.
PW1
yes, yes. PW1.
ସାକ୍ଷୀ ହେଇଗଲାଣି?
ସାକ୍ଷୀ ହେଲାଣି.
Well, here in this case, the trial of the co-accused persons have been completed. The co-accused.
You are an absconder?
I was an absconder.
କେବେକା case କିଏଟା?
These are 14 ମସିହା.
Oh, acha.
And during the trial and also in the appeal, my lord, the co-accused are on bail.
No, but they were arrested, taken into custody, they faced trial, convicted and convicted under 302.
My lord.
And they have been released on bail by this court.
My lord. This court and in some of them under the sessions court, my lord.
ଆପଣ ନାଁରେ କଣ ସବୁ ସାକ୍ଷୀ କହିଛନ୍ତି ମିଷ୍ଟର ତ୍ରିପାଠୀ?
Yes, PW1.
PW1 ହଁ ପଢନ୍ତୁ।
I know the accused person also the deceased Jagabandhu Majhi as co-villager. The occurrence took place 1 year and 2 months back during the month of Boisakha at the Sabarasai of our village in the night. Basanta Khatua took away
Basant Kotwala petitioner.
petitioner. Basanta Khatua took away the deceased Jagabandhu Majhi from his house to Sabarasai. The accused person reside in Sabarasai. In the night, we had gone to see and find out the deceased Basanta Khatua, his wife Ishwara Khatua, were dragging away the deceased to their Sabarasai. They also shouting against the deceased. We found Basanta Khatua and his wife assaulting the deceased with a bamboo lathi and wooden split, having tied him against a Kadamba tree. We requested him to free the deceased, but they did not listen to by complaining that the deceased has committed serious mischief and threatened to kill him. And they asked us to go away. Ishwara Khatua was moving there. Instigating not to leave the deceased. Basanta Khatua told that he would do his work. He and handed over to the man to the police in the morning. We had returned home. In the morning, we learned that the man had been killed. I went to found the dead body of the deceased near.
ଇଏ assault ଦେଖିନି ଖାଲି ବାନ୍ଧି ଦବାଟା ଦେଖିଛି ତାପରେ
assault କରୁଥିଲେ ଫାଷ୍ଟ କହିଲେ ବା assault କରୁଥିଲେ ତାପରେ ଗଛରେ ବାନ୍ଧିଲେ
ନାଇଁ ସେତେବେଳେ ବଞ୍ଚିଥିଲା ସେତେବେଳେ
ହଁ ବଞ୍ଚିଥିଲା ସେତେବେଳେ then came to PW12
12
informant Bharat Majhi. I am the informant of the case. The deceased Jagabandhu Majhi was my son. I know Basanta Khatua and the accused person are all being co-villagers. The occurrence took place 17/5/14 in the night. Due to hot weather, I along with my wife.
Paragraph 2 ରେ କହିଛି ବୋଧେ they tied my son against a Kadamba tree.
Yes.
Assaulted him with lathi cricket bat, beating my son. So
the wife of Basanta was assaulted with a cricket bat.
So where is the order that the co-accused persons who are convicted, they have been granted bail by this court in that criminal appeal?
Already filed, my lord.
Where is that?
BLAPL number 5412 of 2015.
You are
appeal stage.
You just told that in the
CRLA number 646 of
order copy ଅଛି କି ଆପଣ ପାଖରେ?
ଆଜ୍ଞା
ଦଉନାହାନ୍ତି କାହାକୁ କନଭିକ୍ସନ ହେଇଥିଲା 302 ରେ ଯିଏ କି ବେଲ ରେ ଯାଇଛି?
ଆଉ ଅଛି କପି ଅଛି appeal କପି ଅଛି କି
But you were an absconder for so many years. 2000 ପାଖାପାଖି ଆପଣଙ୍କର 8 ବର୍ଷ କେତେ ମାସ ହେଇଯାଉଛି ପଳେଇଥିଲେ ଆପଣ?
The allegation against all the co-accused persons, my lord, they are released on bail. And they are putting...
ପୁଣି କୁଆଡେ ପଳେଇବେ ଧରା ପଡିବେନି ପୁଣି ଆପଣଙ୍କର?
No, my lord, he was there.
ବର୍ତ୍ତମାନ କେସ୍ କୋଉ ପୋଜିସନ ଅଛି?
ସାତଟା ଖଣ୍ଡେ ସାକ୍ଷୀ ହେଇଛି।
ଏବେ ଯୋଉ ଡିପୋଜିସନ ଏଇଗୁଡାକ ଯୋଉ ଦେଇଛନ୍ତି ଏଗୁଡା ସବୁ ଆଗ କେସର
ଟ୍ରାଏଲ
ଡିପୋଜିସନ
1.5 ବର୍ଷ ସେ ରହିଲାଣି ଭିତରେ।
Heard the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 29/2022. He has been charge sheeted under section 302(201) by 34 of the Indian Penal Code. Some of the co-accused persons have faced trial in the meantime in the Court of Learned Additional Session Judge Jajpur in city bracket Sessions case number 365 of 2014, and they were on bail during trial, and after they were convicted by the Learned Trial Court under section 302(201) by 34 of the Indian Penal Code. They have been granted
They are
bail.
convicted 302 and 34 IPC.
It ଲେଖା ହେଇଛି 201 ଯେ order sheet ରେ bail order ଲେଖା ହେଇଛି 302(201).
I'm sorry.
And they were granted bail by this court. He has filed the copy of the bail orders which are taken on record. Further submits that in view of the omnibus nature of allegation against the petitioner, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of the witnesses, and further submitted that the petitioner was an absconder for more than 8 years, and if would be granted bail at this stage, the trial would further linger. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial of the co-accused persons, the release of the co-accused persons on bail, not only during trial, but also during pendency of the appeal, and the period of detention of the petitioner in judicial custody. I am inclined to release the petitioner on bail subject to condition that he shall appear before the learned trial court on each date, and the case would be posted for trial, and shall not try to tamper with the evidence, and violation of any terms and conditions shall entail cancellation of bail. Allowed. Step number.
Assure item number 42.
42, Mr. Prashant Kumar Nando. You have received the case diary, no?
Well.
Okay, none appears and repeated call. Case is adjourned. Some counsels mentioned the matter. पहले पर ସେମାନେ mention କରିଥିଲେ case diary ରେ 3 ଜଣ counsel mention କରିଥିଲେ matter. interim bail ବୋଲି ନା କଣ? କହିଲାନି note କରିଥାନ୍ତେ ନା ଆଉ ସେ ଅପେକ୍ଷା କରିଛନ୍ତି matter take up.
My lord, I am from Dinkel.
Yes.
Item 137, my lord.
He has not brought the file. That is why I am asking him.
Next Friday, my lord.
Anticipatory. So the rest of the matter will be taken up next week.
Item 60 to only notice to go to the informant, my lord. 373, my lord.
60?
68, my lord.
Next week.
कौन पे notice जो कौन offense?
373, my lord.
अच्छा
Next week, my lord.
Item
35.
35 is already over. Some order has been passed. Okay, it has been adjourned, and after 2 weeks it will come.
My lord, 137 will be posted to next Friday, my lord.
It will come next week, and
Pleasure. Pleasure.
So may I make a prayer? It may be unusual. The record has not come. Your lordship has directly call the matter next week.
next week.
Next Friday, at the top of this
say mention कर देगा.
आगे.